Application, your lordship, had heard it thrice. Just
not there.
I know, but it cannot go to any other bench because I was asking the registry.
Keep the memo,
Yes,
give it to the DR. If it is of this court, then
because it cannot go to any other. What the I don't know what system has been made that once your lordship hears it, it will not be listed before any other bench.
that's not the way.
Well, this is the system which is problem for us. That's why I mentioned before the lordship.
Give it to the DR single single other than Tuesday and Thursday. Whatever. Whenever
Whenever your lordship.
first available.
Yes.
Yes. Yes.
Madam, number of 58, 69 and 101, madam, on behalf of Mr. D.K. Mishra, kindly taken over 2 weeks at he heal, my lord.
It will remain in the board.
Madam?
Thursday. It will remain in the board. It's
One
weekend.
chapter, my lord, one chapter, my
Note it down.
58, 69 and 101.
Okay, let it be there. We'll see. Yeah. I'll recommend it. Yes.
I may be pardoned, my lord, on BC, my lord.
Yes.
My lord, am I hearing, my lord? Item 24, my lord. I have taken consent from the opposite party. I pray any day, not today. Thursday is my lord, previous other taking matter. It is taken also.
24. 24 Thursday.
You may pray for a short
My lord, oblige, my lord.
24.
20
Mal-
before any date before that.
Thursday.
Or this.
Thursday. It will remain.
I'm
Mal-
sorry. I heard
Not today. Not today.
I'm sorry.
Oblige, my lord.
Yes.
Item number, my lord, 4.
Or it will reach within 2 minutes. Wait.
Report.
Item 1.
Item 1 for report.
Report is there. 1 to 6. 1. The vigilance is now. Nobody should be. What will be able to be 4/9/2025. The report is from report by IIT and the case 25 August 25. September order, August 25 order. Who is giving this? See, 4/9/2025 the order is there, and the report is 19/8/25. Mr. Panigiri. Yes, Mr. Panigiri.
My lord, all the family members have left the village.
No, that's right. This is an order. This is a report of August.
I will obtain another report.
That's what
Press report.
direction was.
Press report.
I will obtain.
4/9/2025. Right. Mr. Panigiri, you want more listing pattern next week. Live. Number 2. You are appearing for in item 2?
Yes, ma'am.
Oh,
Item 1.
item 1. Item 1 is over next week. Yes. This report UFO 783. Here also the same thing. See, the order was passed on 15/7/25, and you are giving me an order prior to that. And I have noted that if report is not obtained, serious will be taken.
I will obtain another report.
15/7/25. All these things are pulled out this thing, report. 15. 15/7/25 order not complete. One last question here. Item 4.
এটা 7/8/2025 রে আসছে 3টা।
Full appellant.
লাস্ট অর্ডারটা 15/7/2025, আইটেম নম্বর 3।
The full appellant, Tuna Elias Loknath Das, is effective of expired as per the report dated 6/2/2025, filed by I sit down to Kana. Yes. 4, 5, item 10. 5, no report. No, 5 goes.
5. No, 5 no.
10, this is 10. The same problem. The old reports are, you are giving all old reports.
I will obtain fresh reports. No, that item number 4.
10, I am talking about 10. This is,
10 is
So the 10 is concerned with that.
uh,
That is the report. There is 5, 8 in that.
yes, 5/8. The order was passed on 19/8.
No, that first order was passed on 5/8.
Uh,
The
on that day you
matter
got,
was listed on 5/8/25, call for the report. And report has come on 25/8/25. The 5/8 order, we have received the report on 25/8/25.
dated 5/8/2025 and order dated 19/8/2025. The IIT Ranpur has submitted a report to inter alia stating that the sole appellant is found in the line and residing in the Sikarpur village. We have received the appeal is ready for hearing. However, none appears for the appellant since last more than 2 years is hearing in view of the same, so we wanted to make it fully. So you can speak. Yes. It's including the next, which is, yes.
11, we pay some more time.
11,
Report is not available, I will pay some.
11 report.
Eyebrow lines, 11 to 14.
Report is not there. Next week, yeah? Next week, okay.
Item 7, sole appellant is dead.
Died.
Right.
7, where is the report?
Died on 6/10/2016. Report is of 11/8/2025.
According to the order dated 15/7/2025. A report dated 11/8/2025. IICTC has been placed on record. As per the report, the total appellant Jamaru Maji has already expired on 6/10/2020. So 2016. The lecture is taken on record. We are consulting appreciation also. A bit, yes. Yes. Good.
Item 15.
Thank you. Last occasion, my lord has formed the report of the Vigilance judge. My lord was unhappy. And I am just submitting, my lord.
The report has come.
Report has. আসলে হজুর সেটা দেখতে নেবে
What was the last order?
কিছু নাই The order was received, my lord, 11/3/2025. That was not reflected in the order sheet. That is not the question.
Report was not received, then
না হজুর হয়নি
18/5/26 report was not received. Thereafter, report is received.
that is on 29 April 2026.
5.
Sorry. 15 May 25, 6.
15 May
26, my lord. That's 385. Letter number 61, letter 15/5/26, your lordship.
Glad?
My lord.
385. Glad. Okay, let us see. Yes.
Then, your lordship, I have given all, my lord, dead chat, reflecting everything with regard to delay.
From 2013.
Ammo Pais are 180 days delay. We have given entire lordship, we have reflected.
But
Then, your lordship, my lord's judgment, I am just pressing before you. May did that I have filed. Referring my lord has quashed similar case.
Which judgment?
Referring Jans, my lord's judgment.
Your written note of submission?
Yes, that I have given.
Okay.
Setra Ochi 60, my lord has referred Jansin versus State of Punjab or another.
Yes,
Here is a case, my lord. Once effort is submitted due to insufficient of evidence, after long direction of this honorable court, number of times, number of writ application and lordship's order, specifically 3 months, ତା ଭିତରେ ବି 2.5 ବର୍ଷ ପଳେଇଲାଣି କିଛି ପ୍ରୋଗ୍ରେସ ବି ହେଇପାରୁନି କେହି ନାହାନ୍ତି and my lord, when there is big chance of any conviction, last occasion my lord was had this matter on length.
Yes.
So,
Now how many witnesses have been examined?
ସେ ଗୋଟିଏ ତ ସାର୍ ସେ ଗୋଟିଏ
And PW2 also.
PW2 ରେ କିଛି ନାହିଁ ତାର material ସେ କିଛି ଜାଣିନି.
Material is different. I am not on
No,
merit.
say,
How many witnesses have
my
been
lord,
examined?
I am just what he has written, my lord, with regard to 2.
No, I am not on merit. I am not.
ନାଇଁ ସେଇଟା କହୁଛୁ ବା 2 ନମ୍ବର ସେ କହୁଛନ୍ତି PW2
Yes.
examine in chief, my lord, after framing of charge, E. Purnachandra Patra has been examined as PW1, whose cross-examination has been declined. Thereafter, on 7/12/2024, one Sudhakar Pahi is present and he is examined in part as PW2. The examination in chief PW2 has been deferred on the petition filed by the Land Council for the Vigilance, my lord.
For non-availability of some documents.
Yes. Yes, ଆଉ ଡେଭଲପମେଣ୍ଟ କିଛି ନାହିଁ ଆମକୁ ସିଆଡେ ଡିପାର୍ଟମେଣ୍ଟାଲ ପ୍ରୋସିଡିଂ ରେ ଆମକୁ ଡିସମିସାଲ କରିସାରିଲେଣି।
Okay, I'll pass you.
And-
Who is appealing for this?
That is a case of vigilance. It is coming.
ସେ ଦେଇ ଦେଇଛନ୍ତି ମିଲର ତାଙ୍କ ରିପ୍ଲାଇ ବି ଦେଇ ଦେଇଛନ୍ତି।
I'll hear him for 5 minutes and
Okay.
I'll pass you.
Much. My lord, one thing may I submit? This book is required. Just passing. Because this guideline we have followed as a government employee. আমি ଦେଇଛୁ ହଜୁର ତଥାପି ଏଟା ଦେଇଦେଲି
No, ଦେଇଛନ୍ତି ତ।
ତାର ଜେରକ୍ସ କରି ଆନେକ୍ସ କରିଛୁ ଷ୍ଟିଲ୍ ଦେନ୍
The only problem is you approach the court many times.
no for the purpose of proper adjudication and only disposal.
That's right, but you came at the cognizant stage which was dismissed.
But that was ସେଠି କ'ଣ କହିଲେ 120 days
You have invited all these orders again.
ଆମେ ସାର୍ ଆମେ ପଢିକି ହଇରାଣ ହଉଛୁ
Obviously, that's not the issue. Issue is
କୋର୍ଟକୁ ଆସୁଛୁ ଆଜ୍ଞା ଜଲ୍ଦି ଟିକେ ଡିସ୍ପୋଜ ଅଫ୍ କରନ୍ତୁ।
there are two problems.
ସେଠି ସାର୍ କ'ଣ ହେଇଛି ସେମାନେ ୱେଟ୍ କରୁଛନ୍ତି ଏ ତ ଫିଟ୍ କେସ୍ ଟୁ ବି କ୍ୱାସ୍ ଏ ତ କ୍ୱାସ୍ ହବ କିଛି କରୁନାହାନ୍ତି ବିଲ୍ ପକେଇ ରଖୁଛନ୍ତି ସାର୍ ଦ୍ୟାଟ୍ ଇଜ ଦେୟାର ଅନ୍ ଦ୍ୟାଟ୍ ମିଲ
They are fixed.
ସେ ଭଲ
You have, I'm telling you, you have two problems. One problem is repeatedly coming to the court and taking
ସାର୍ କ'ଣ କରିବୁ ଆମେ ହଜୁର
Just tell you.
Yes.
Next problem is there are many accused. One accused or the other is seeking time or coming to the high
No,
court,
no,
taking
no.
a stay and all. So that's the reason the delay is caused.
no delay is
You might not have contributed any delay, but you have to see the other co-accused.
My
your
lord, on
friends.
last occasion I appeared one Aditya Naik has died because 5 accused person I am appearing.
NVWs are issued.
He
is going.
My lord, he is already dead. NBW issue. ସେୟା କରିକି NBW କରିକି ଗଡୁଛନ୍ତି।
In these kind of cases, you have to see if passing is yes, Gyan Singh applies.
That's
But you have to see attributability factor.
yes.
Whether it is attributable to the accused persons or the prosecution.
My lord, for the prosecution, that's why I have given the chart, my lord.
I'll-
How many days? 120 days delay.
Entire proceeding is there.
Yes,
with me.
that-
I'll just see and whatever best possible.
Item 12, we have received a instruction there, but that instruction is not up to the satisfaction. No such person local there, no such person is living in the name of Alok on the present offense.
You want to get a press report?
Further clarification.
Press report. wow.
Press report.
You get press report. Yes.
15th order is
Judgment. Yes. 142. Yes.
Item 16,
not press your lordship.
Not press.
Yes, sir.
Item 15 was. Sorry.
1 minute. 1 minute. Your Vakalatnama is there? Just take it up. Give a memo, huh?
Yes,
Give a memo. Okay. Not pressed. Yes, next.
item 17,
Bail. Bail. Yes, next. 18.
item 18,
Item 18, I have filed a miscase for extension of interim bail. While disposing of this bail application, on 14/5, my lord has granted 45 days for the treatment of the father of this petitioner.
Yes.
That interim bail is going to lapse on 2nd. Maybe another 4 weeks, my lord.
What happened on 21st? What had happened? Essentially, I has been filed the essentially.
30 दिन ହେଇଯାଇଥିଲା ବୋଲି ଆଉ ଥରେ ଗୋଟେ ଆଇଏ ଫାଇଲ କରିଥିଲି ସେଟା 45 days inadvertently ହେଇଯାଇଛି।
And then now it was extended for another 15.
नहीं से your lordship has directed to 45 days first date on 14/5, but it was inadvertently typed as 30 days for which I have
They have
filed.
removed an application.
Yes,
I made it 45.
45 days.
45 days.
But that was
45
correct.
days is also expiring.
Yes, on 2nd.
Okay.
Only 4 weeks, ma'am.
No, but you tell us why.
My lord, the one side of the body was paralyzed, my lord, the father of this petitioner.
Yes.
He is undergoing treatment at MKCG.
Can you please verify it
My lord,
day after tomorrow?
my lord.
Verify the application.
Yes, my lord.
My daughter dated
Copy medical document medical document
5/26 and 21/5/2026.
instruction लिख कर
Petitioner was granted 45 days.
Verify करिए पड़ेगा ना.
पुलिस को कह दो instruction
The ground that his father is, your father is the
yes
undergoing medical procedure.
Medical documentation.
Verification
Verification कहीं करिए सर वही दे My lord, I have not enclosed any medical report because
Yes,
only on instruction I have.
Well, he has to verify, that's it.
Yes.
4 weeks changes. Issue notice to and by next Thursday, yeah?
Second, that will
Thursday,
expect.
second, na? Thursday,
Yes.
huh? Second, that's the okay.
That is the 2nd July.
Yes.
27
Because it is expiring on that day.
on that.
If it is required, we will extend for another. Whatever. Yes.
Problem.
Item 19,
Extension of date of surrendering.
NBW pension, what? Bail granted.
My lord,
Then
due to communication gap, my lord,
what communication gave?
by your lordship directed to surrender by 10/5, my lord. 9/10
Which paragraph? Let us see.
my lord, in paragraph. Paragraph, my lord, 5, my lord.
Well, which part? Okay.
It is directed in the petitioner
It is
surrender.
directed that in the event the petitioner surrenders before the session. Then how much time you need?
So 1 week time.
Right. Why don't we take 21/4/2026? The petitioner was directed to surrender which was this board below on 10/5/2026. The petitioner bids that he could not surrender as the stipulation. If you the time frame granted by this court, and she seeks 2 weeks time, huh? Not 2 weeks, huh? You tell me 2 weeks means today is 30th, isn't it? 15th, huh?
My lord.
15th. On or before 15th, that's what to be made clear that no further extensions can be granted on any ground. Yes.
Problem.
item 20,
Please, my lord, I pray for modification, lordship. GR number has been wrongly typed, my lord, as my lord 7/2023 instead of my lord
Year number?
1809 of 2022.
Okay. In your application, what have you written? In your application, let us see the application. Year number?
The correct number, my lord, 1809 of 2022. I have stated, my lord,
No,
7 of
you come to your application.
Lordship.
Anticipatory application.
Lordship.
Anticipatory bail application, just see the top. PS case number 381 of 2022 corresponding to GR case number 7 of 2023.
Lordship. PSS number correct,
Huh?
but GR number wrongly typed.
What is the GR number then?
Correct number 1809 of 2022.
Huh?
1809 of 2022.
Oh, that's right. But in the petition, you have everywhere you written 7.
Lordship. I have filed.
Then why are you saying that my order is wrong?
No, mine.
You have to correct your petition.
My petition.
But you correct your petition, then only.
Lordship order correct. Lordship.
So then you correct your petition. Where is your application?
IA number
IR
972 of.
you need to correct your application, sir.
ସେଥିରେ କ'ଣ ହେଇଥିଲା ଲର୍ଡସିପ୍ ନୂଆ କୋର୍ଟଟା ଖୋଲିଲା ସେଟା ଆକ୍ଚୁଆଲ ମୁଁ କରେକ୍ଟ ନମ୍ବରଟା ଦେଇଥିଲି ସେ କୋର୍ଟ ଖୋଲିଲା ଯେତେବେଳେ ସେଠି ହଉଛି ଚେଞ୍ଜ ହେଇଗଲା ଏ ନମ୍ବରଟା ସେଥିପାଇଁ ଏ ନମ୍ବରଟା 1809/2022 ରହିଲା
ଏ ଯୋଉ ଜିଆର କେସଟା ଆନେକ୍ସ 1 ମଧ୍ୟ 7/23 ଲେଖା ହେଇଛି
ହଁ ସେଟା ତାଙ୍କ
Everywhere.
ସେଥିରେ ଥିଲା କିନ୍ତୁ ସେଟା କୋର୍ଟ ଟ୍ରାନ୍ସଫର ହେଇଗଲା ଏ ନମ୍ବରଟା ହେଲା
It is found from the record that in the entire petition for which is to be, the petitioner has mentioned PS case numbers also corresponding to the number 7 of 2020. Therefore, in the order details also, the DR number is DR number 7 of 2020. However, the petitioner, by way of this application, submit that inadvertently in place of GR number 1809 of 2022. So 2022, GR number 7 of 2023 has been mentioned in the petition for which he seeks. What is it? Taking the application, the GR number as reflecting the anticipated after this petition as well as the order. Yes. Next.
Date of surrender.
Importance of this that in view of testimony. You could not, what item number declared 20. What was the direction? Surrender. Could not surrender before the court below. Right to the direction of the court before 30th of October 2026 and 6 time. 15th of July.
Okay.
21.
Make that more. 21. Yes. Yes. On the page. Yes.
कोई जैसे order में रखते हैं.
Urgent. Yes.
22.
कोई
May I please your lordship?
Yes, 22.
I am on VC, my lord.
Mr. Mohanty, Tanmay Mohanty.
Sir, I am appearing for the petitioner, sir. It is a dispose of case. A I has been filed by the informant. Sir, copy has not been served to me. What purpose the I has been filed?
What is this I, madam?
I am informant, your lordship. I have for mediation, refer to mediation, your lordship. Petitioner grant bail on 25, 2026 and he petitioner willing to mediation center the amicable.
You supply the copy of the application to Mr. Mohanty. Let him see if he is ready for mediation. No problem. I can send.
Yes, your
Okay?
lordship. Yes, your lordship.
Dispose of cases. Sir, your honor grant the bail.
Season 9, Learning Council appealing for the applicant of the complainant undertakes to supply the copy of the IA number 1028 of 2026 to the council, Mr. Tanmay Kumar, who is of the petitioner. Let him do so. You can do the matter next week. Next Tuesday. Yes.
Oh, please, your lordship.
23, my lords. Lordship has been pleased to allow the application for pre-arrest bail, but there is a complaint case, my lord. Lordship has directed for the event of arrest. May I pray for
Where is that order?
that order dated
17.
no 25 2026.
This is item number 23.
20. Lordship has taken note of the order passed by the coordinate bench, that is at para 6. 27/4/2026, the coordinate bench has directed on surrendering released on bail. Lordship has directed.
Where is that order? I'm just wondering. The order is not there.
Madam? Order of my lordship.
Yes.
That is that order is just
Yes, I got it. Yes.
third page, में, fourth page.
Fourth page.
But
Para?
25 para 6 lordship kindly have a glance. 5 and 6.
I consider the petition submits that the coexistence has already been admitted to bail by the coordinate bench by the order it so regarding that to the nature of information admitted. The coexistence has been admitted so yeah, what do you want now?
My lordship has directed in the event of arrest by the arresting officer. It is a complaint case, man.
Okay.
So IO has got no role.
Yes, yes. And
Lordship,
that part has to be correct.
Yes.
That part is correct. Right.
For that I have filed a
Right. By way of this application, the petitioner is seeking modification of the order I did 28 May 2026. Mr. Vishal and Council the petitioner submits that in present case is arising out of a complaint. Therefore, the direction contained in para 6 to the effect that the event of arrest by the arresting officer, so the petition shall be released bail subject to verification of several instances. Needs to be on the fact of the release. This case arising out of accordingly the para 6 stands modified regarding the two natures of property. I am inclined to I am inclined to grant the petitioner anticipatory bail. Accordingly, the event of arrest, the petitioner shall be
In the
granted bail, anticipatory, granted anticipatory. That's all. I leave it there. He shall not be arrested.
but arrested, it is a
He will
complaint
not be
case.
arrested. Then,
It's a complaint case, man.
then
Shipment direct on surrendering, I may be released on bail. The coordinate bench has also granted that order. In
where is that order then?
The Lordship has taken note of that.
Yes.
3206 of 2026.
Complete case on the petitioner will surrender the court report. This will be released on. He shall be released on bail on the condition as you case to be enforced.
Obelisk.
Yes.
I'm sorry, my lord. Item 15, your lordship has that. I'm giving you just short note, your lordship.
I have heard it.
Your lordship. I was in leg on another court and here you was going on. That's so.
Yeah. 25. What happened? 24. Manachal. Yes. 24. Yes.
Please, my lord. In all these 4 cases, petitioner has
Last time it was urgent because was there any chance of settlement?
But actually, my client's wife is ill. So he is busy with her treatment at Delhi. She is seriously ill for the last few months.
But there is a chance you have not explored that possibility.
Because of the fact that he couldn't come, he is attending to her, my lords. I couldn't discuss that aspect.
Yes, last order it is.
Yes, I concede.
Was appearing for the parties.
I agree.
The instruction regarding the possibility.
I agree.
High Court's instruction, they're not possible. What he gathered from them. I think my friend also told me that it's not possible. But
Then let us proceed. If it's not possible, then quite weak. Because even one party is not agreeing, and then also it goes. Even his client will be agreeing. Your client is
not agreeing. My client has spoken to them and told me that as per his discussion, it's not possible.
The facts are like this.
The note we have giving directors to give us the notes.
Yes.
So
I will ask your lordship to kindly look at page 28 of the brief.
28.
My lords.
Yes. Give me the little facts.
The facts are like this. my lords. This petitioner SAG projects entered into a MOU with Siddharth Engineering Limited for supply of technical inputs, my lords, because it was a bidder for a power plant, my lords, on turnkey basis. And this MOU is at page 28. In terms of the MOU, my lords, clause 2F and clause 2G, they stipulated that the payment, the manner of payment and modalities of payment were stipulated there.
Yes.
Now, if my lords will look at page 29 of the brief,
Yes. I'm there.
Clause 2.5, it says, notwithstanding anything to the contrary, in event of award of the said project, two SAG projects by the owner, UP Power Transmission Corporation Limited. SAG Projects has agreed to pay ACL technical service fee for providing the said services, and the fee would be 1.8% of the total contract value, which is to be exclusive of all applicable taxes and duties. And the modalities of payment have been given in a tabular form. The technical service fees have been computed at 59 lakhs 9,400. Then, my lords may see, clause A.
Totally 59.
Yes.
Yes.
Clause A says the first installment payment 0.9% of the approximate estimated cost of 29 lakhs 54,700 only of technical service charges as detailed in 2.5 above immediately on receipt of LOA from owner UPPTCL.
Yes.
So this is where, my lords, payment starts. The first installment is to be paid immediately on receipt of LOA.
Yes.
Thereafter, it says second installment is within 3 months from the first installment. Third installment is again within 3 months thereafter. Fourth installment is again within 3 months thereafter. And then, depending upon the final, since this has been fixed on an approximation, depending upon the final awards, if anything is payable remains, that is to be paid in the fifth. Now, my lords, what the opposite party did was, they did not wait for receipt of LOA, my lords. When, my lords, payment became due to them. As per clause 2.5a, payment became due to them immediately on receipt of LOA. Now, UPPTCL, my lords, issued a letter of intent to me on 3/9/2021.
3/9?
2021.
LOA is 3/9/22.
21.
Yes.
So, the payment did not become due then. But, my lords, on 13/9/2021, they sent a letter to me.
21, letter. Yes.
They asked me to pay the first installment by RTGS and asked me to give fresh post-dated checks. I did not respond because LOA had not been issued. First installment was not due. What they did
It
was...
was due after 3/9/21.
No, it was not due. Because by then LOA had not been issued.
That is letter of intent, you say.
Yes, letter of intent and letter of...
LOI was issued.
Yes, letter of acceptance had not been issued.
LOI.
Yes. As per the clause at page 29, the first installment fell due
only LO
immediately on receipt of LOA.
Acceptance.
Yes. And therefore I had given 4 undated checks, my lords. Blank undated checks had been given to them.
When LOA was issued?
LOA was issued on 22/3/2022.
22/3/22.
By then, my lords, cases had already been filed. And the parties were not in a mood. One other thing they did, your lordship may look at.
Was there any condition for issuance of post-dated check?
Yes.
Contract? Where is that?
Yes, that your lordship may see. Page 30.
30. Yes.
Clause F.
F.
My lords. SAG projects hereby release payment in shape
Undated checks. Undated.
4 undated checks to ACL, which shall be used only for the above purpose and not for any other purpose under any circumstances.
Yes.
G. For the above purpose, the following undated check has been issued by SAG projects to ACL, which shall be kept with ACL as security. And then serial number, check, date and amount. Now, my lords may see, these, what has been filled up, my lords, has been filled up. Your lordship may see the signature in the margin. This signature belongs to Siddharth Engineering Limited.
This beside signature.
Yeah.
Yes.
So they unilaterally filled up the dates in the checks. They filled up the amounts, which they should not have done. Had it been done in consultation with me, my signature would have also.
Why you have signed it in the blank, leaving it blank?
No, it had been given like that, my lords. The MOU had, which was.
Just in the end of this page and the below,
Yeah.
you have signed it.
Yes.
And it appears that it was left blank.
Yes.
And which was filled up by them.
That was left blank intentionally because, my lords, the checks should have been paid in serial, my lords. When the first, second, third, and fourth installment payments would have been made and the checks would have been returned.
As and when it occurred.
Yes. They were not meant to be encashed or presented for payment. But if your lordship will look at page 31.
31, yes.
Now your lordship may see the second check in the series was presented for payment first on 30/10/2021.
Okay.
When LOA had not been issued. Then he has put the date for the first check as the second payment due on 31/2022, the third check on 34/2022, and the fifth check on 37/2022.
Yes.
This was done unilaterally and subsequent to my signing the MOU and handing it over to them.
Because the signature, there is no countersign.
Yes. Then, my lords, after that it says 2.6, SAG hereby undertakes to indemnify and keep indemnified SEL from all liabilities arising out of or in connection with the contract agreement to be executed. So, this clause, my lords, has been violated by them. They presented the checks before the LOA was issued. Only upon letter of intent being issued, they presented the checks. When the checks had not fallen due for payment and the checks are security checks which were not required to be presented by them.
There is an arbitration clause. Have you invoked arbitration? 16.
No, I haven't. The 16 is shall be settled amicably by negotiations and conciliations. They have not done any negotiation.
16.2.
16.2 says it shall be settled. 16.3 says courts at Bhubaneswar. They have neither evoked the arbitration clause, but straight away they filed these complaints.
Yes.
And 16.3 says courts in the city of Bhubaneswar to have exclusive jurisdiction. So complaint was filed at Bhubaneswar and I had to come and appear, my lords, because warrants were issued.
I am just wondering, why have you not invoked the arbitration so far?
That is because, my lords, I came to know only after the complaints were issued, warrants were issued. I appeared in the court, got the warrants recalled, and I have approached your lordships.
That's it, parallel proceeding.
Yes, I have not done
parallel
so.
Proceeding.
I concede I have not done so.
Yes. Yes. This is what your case is.
This is my case.
Let us see the notice under 138 NIA.
Right, my lords.
And your reply.
They have not been filed along with the petition.
No, it is there at Annexure 6. The one that notice is there.
Which is 6. Oh yes, page 42, I believe. January 5, 2022. Under instructions for and on behalf of my client, page 42, my lords. So and so, I serve upon you the following notice. We are not concerned with clause 1. Now, my lords, may look at page 43,
Yes.
paragraph 4.
Para 4.
Yes.
2.5.
2.5 of the MOU dated such and such provides for terms and stages of payments. My client accordingly requested you to pay the first installment of technical service fee of rupees 29 lakhs and odd, which you were liable to pay immediately on receipt of LOA. CV caution.
Yes.
However, you informed my client that land has still not been allotted to you. Though the first payment to my client was not dependent upon allotment of land to you, my client waited, verified this fact, and it was clear that land for proposed substation is already allotted and construction of boundary wall was in progress along with drawing approval work. My client immediately informed you telephonically that work is in progress, you should make the payment, perform your obligation, and you asked my client to deposit Yes Bank check number 013442 dated 30/10/2021. Now, undated checks, my lords, my asking also doesn't arise asking them to deposit. And this notice also, my lords, that has not been served on me. That is apparent from Annexure 5.
If you see 45, page 45,
My lords.
there, successfully delivered. Service is there.
ସେଇଟା 41 ଟାକୁ ଆଜ୍ଞା ଦେଖନ୍ତୁ ଆପଣ ଦେଖିବେ. Look at 41, column 7, 8, 7 and 8, SAG projects, Raghuvar Puri, Vishnu Agarwal, SAG project.
Have you replied to this?
I have not received these notices. I became aware only when warrants were issued.
Let us see the complaint copy. Complaint.
Page 18, my lords may see.
18, 1-8.
Yeah. Page 18, paragraph 13. That this, no, ତା ଉପର ପାରାଟା ମୁଁ place କରୁଛି. Fourth line. Said legal notice was sent through DTDC courier and registered post within the statutory period provided in 138 of the NI Act. Copy of legal notice dated 5/1/2022, annexed and marked as Annexure 6. Then what he says is, statutory legal notice dated 5/1/2022 was sent to the registered address of the accused company. Copy of notice sent through courier was delivered on 8/1/2022. However, the notice sent through registered post has been returned with a remark not claimed by the postal department. Copy of receipt showing delivery of notice upon both accused along with envelope returned by the postal department is annexed and marked as Annexure 7. Both accused, in spite of getting statutory legal notice dated 5/1/2022 under 138 NI Act, failed to make payment nor responded to the legal notice.
You have not replied.
I have not replied because I have not received. And I have stated at paragraph 2 in my petition paragraph 3, my lords, page 5, that as per MOU, payment was to commence on issuance of LOA and not on issuance of LOI issued on 3/9/2021. page 5 of the brief, your lordship may see. Then your lordship may see what I have stated at para 4.
But you tell me whether legally recoverable debt,
Yes.
which is required to be proved by
When does it become legally
whether
recoverable?
it is a
My submission is this.
it is a disputed question of fact.
It is not a disputed question of fact at all. It is not because of their own averments in their complaint. What do they say, my lords, in their complaint? At page 17.
Yes.
They say,
They also say that accused number 2 has assured that you give some time, I'll make
These are
the disputed facts to be established.
Paragraph 13 and 14 I placed before your lordship.
Yes.
At paragraph 13 they say, copy of notice sent through courier was delivered on 8/1/2022, but notice sent through registered post returned with a remark not claimed. And then they say, both accused, in spite of getting the legal notice, failed to make payment within stipulated statutory period.
Yes.
Now, my lords, my submission before your lordship is this. Now, as per the MOU, my lords, undated checks had been given. The checks were not required to be presented for payment as per the MOU itself. What does the MOU say? I am placing that again.
Yes, I got it.
The MOU says that 4 undated blank checks should be given. That is at page 30.
There are 2 cases, na?
There are 4 cases.
4 cases.
4 checks.
All the 4 cases.
It says, following undated checks have been issued by SAG projects to SCL, which will be kept with SCL as security. And payment, it says, is payment is to be made immediately on receipt of LOI. It does not say, MOU doesn't say that the checks which are given will be used for being presented for payment. So the checks were not issued at all, my lords, to be used when payment fell due.
If the payments are to be made with the subject to the interpretation of the clause of a contract.
Yes.
If there is an arbitration clause.
Yes.
In the absence of invoking arbitration clause.
My lords.
Whether a 138 court.
It will not be maintainable.
Can interpret the clauses of the contract.
It will not be maintainable at all.
That's a different. Whether the 138 court can interpret the clauses of contract.
138 court cannot interpret. It can only see whether it fell due or not.
You are trying to impress upon the court saying that if the contract conditions are arrayed, then the legally recoverable object under 138 cannot be proved because it is contingent upon issuance of acceptance.
That aspect the 138 court can determine because that is on record. The MOU has been filed by them. It is on record.
Is it a part of the complaint?
Yes. It is annexure 2 to the complaint.
Show me the index or the document.
That is annexure 2 to the complaint. Your lordship may look at page 22 of the brief, 23.
Document relied upon.
Yeah, 22.
So, demand notice.
Number 3 ala memorandum of understanding executed between both parties.
It's part of the part of. Yes, sir. What do you think?
Yes.
I understood.
Beloved, what is on the challenge here? Order taking cognizance of offense under section 1. When a complaint is filed before the magistrate, what the magistrate is supposed to look at before taking cognizance, that the ingredients of section 130 is applicable on record. A check signed by the accused, check was presented, returned,
Yes.
so there is a return memo. Then person that within statutory period in legal notice has been given. to make the payment of the amount covered under the check within a stipulated period as per the statute. If it's not paid within 15 days, from the 16th day, all the taxes starts. So what the magistrate saw in this case, there is a check signed by the accused. It was presented back. There's a check returned in memo. Pursuant that there is legal notice. Notice they have received. Payment have not been made.
The
Who has
service of
received
notice,
just-
service of notice is a bit dicey
No,
by
no.
reading up your complaint.
That have not taken as a ground in their petition. Regarding notice, they are completely silent that we have not received the notice. So ingredient was not so. What they say? So after seeing all these documents, minors, as per requirement of 113, court has taken cognizance. So while examining the matter at this level, even as this court will see, yes, whatever matters the court had before it, so it was sufficient to take cognizance. Number one. Number two.
No, technically you may be correct. What I am trying
No,
to
I'm coming to that. I'm coming to that. Their entire petition, only ground that as per the MOU, check was to be presented on a particular date. In the complaint, it has been mentioned, in the notice also have been mentioned to them that occasion had come for the fast check. Because that's the only technical service, no other service. And to present the check, they consulted them. All these are factual dispute. So their entire case is, there was no legally enforceable debt. There is no legal enforceable when the checks were presented or when the court took cognizance. This is their entire case. When court takes cognizance, court will see these documents coupled with section 139
presumption.
that the holder of the check has received the check in discharge of date or annulment.
Presumption of it.
Yes, ma'am. And that presumption is a rebuttable presumption. He has said, to explain that, prima facie, in the complaint, he has said, yes, there was occasion for me, there was a date, there was a liability, so I presented the check. Then, court saw all these documents, also, court cannot ignore 113. When the check is admitted, check is not disputed, it's admitted. When check is admitted, the court is bound to draw presumption that the holder of the check has received the check in discharge or due discharge of liability. So all that is now being submitted here. This regarding check, they have not mentioned anything. Regarding the notice, we have not mentioned nothing, not a whisper in this proceeding. Only cases there is no legally enforceable date to deposit checks.
Yes.
So that is the difference. That's a 100% difference. Even MOU, MOA, regarding MOA, whether terms conditions are there or not, we say it was there, referring to documents. You say it was not there. All these are matters of trial. All these are matters of trial. So I have told the court, prima facie, section 130 ingredients are there in the case. Coupled with 139, court has taken cognizance, issued notice. You may have a very good case in trial, but how do you expect this court to go to your defense or your possible defense, what you could have taken there? How this court should go and retrospectively look at 2002 when court took cognizance that not only you couldn't have taken cognizance because even if 138 ingredients are made out, you could not have taken cognizance in 2002 because they have such a defense available with them. Can this exercise be done? My entire note is that one judgment of the Supreme Court, which has summed up all these judgments, is sufficient.
Facts are different. Four written notes. Facts are different in all the four.
No, all cases are same. All four cases are same. Four notes are given.
Okay, four.
I don't want to trouble your lordship to going through the note now because
So many are judgment.
note is based on this judgment.
Yes. 3 ohm sales, huh? They're relying upon 3 ohm.
I'll place para 11.
Para 18 you read it, ohm.
Yeah, man. I'll start from para 11.
But 18 is the ratio.
18 is the ratio. And back to that, all previous judgment found exactly on the same point. Court has, even in my note, I have exactly done that.
The ratio is 139 presumption operates is being a rebuttable presumption. It is only the trial court where accused has to rebut the presumption. And the 482 court doesn't have jurisdiction.
They may have a very good case. I don't deny. Very good case they may have.
Yes.
But that is again amounts to that rebuttal of a presumption.
Yes.
Can come into only through the at the process of trial. That is my case.
Yes.
I've given note.
On Regent?
Yes. I am not asking this court to go on a roving inquiry because
yes, it is. Starting from notice to MOA, whether MOA was there, MOU is there or not. We say it was there, very much there. We say we filled up all the terms conditions of MOA before presenting the check. We say you
are you
advise.
disputing the address? Address you are not disputing.
Lords, I am disputing their basic case, my lords, that the checks were due for payment and the checks were presented for payment. My learned senior friend is harping upon the fact, my lords, that this is a rebuttable presumption and I may have a very good case in defense. My lords, who asked my learned friend's client to file the MOU along with the complaint? When the MOU was filed along with the complaint, what do they say in the complaint? At paragraph, page 15, my lords, may kindly see what they say.
Yes.
They say that SAG Projects is the accused company, Vishnu Agarwal is the director. And the accused requested complainant to assist the company in bidding for construction of a project on turnkey basis. Then they say that they accepted that request, gave me those credentials, and it was decided that payment was to be made of such and such amount. Paragraph 4. At paragraph 5, what do they say? That a memorandum of understanding was executed between the complainant company and the accused company on 10th June 2021. According to clause number 2.5 of that understanding, the complainant company had to receive stage payments from the accused.
There is a recent judgment of Justice Monmohan. You get that judgment? That judgment covers everything. Justice Monmohan's judgment. Recent judgment.
I get it. Another subject.
No, that covers everything. 138, all aspects is taken care of.
I'll get it.
They
Your Lordship may call it next week. I'll also check.
Thursday, you get that judgment.
No, not Thursday.
Only
Thursday, I am not there.
Only
I'll reject the judgment. You give it.
No,
Only
your
the-
Lordship need not reserve it. Your Lordship has to hear it. Because I have not completed. The answer to my learned friend's submissions is in the complaint.
Argument of both of you is taken care of by Justice Monmohan in that judgment.
I don't think so. Unless I read the judgment, I will not agree with what your Lordship says.
Okay, you read it.
Because
Nobody can stop at that judgment.
their
Answer.
Their own complaint, my lord, says about the MOU, how it is to be dealt with.
And cognizance states.
If it is the submission of my learned friend that the magistrate at cognizance is a post office, then I have nothing to say. If he is not a post office,
In 138, what are
yes, whether it is 138 or whatever, he has to apply his mind. That is what the law is from the very beginning, that at the time of taking cognizance, judicial mind is to be applied on the facts of the case. So if the facts have been pleaded in the complaint, the magistrate cannot, like a post office, merely because a check is there.
Read that judgment.
I'll read it.
Tuesday.
I'll read it.
You get that. This is Monmohan's judgment.
I have been reading for the last 40 years, my lords. I'll read it.
No, nobody can doubt.
No worries. No. I don't mean
He
to
is
say
only saying
anything
that
else.
you are not reading.
I
That's what
don't mean to say
indicating,
anything
indicating
else.
the quote that you are.
I don't mean to say anything else. I'm only talking of myself. What do I know of you or of the court?
Definitely, we have to read.
Let it be next Thursday. Even 7th, I'm
Next.
9th.
Let it be in the weekly list. If you are there, it's all.
No, let it be on the 9th. Let it come on the 9th specific.
Part her, partly her. Ninth, huh? Ninth, it's made clear that no further agreement. Yes.
The answer to what my learned friend says is not that. I can only speak about myself. I neither know him nor I know your lordship. I only see your lordship in court, and I have seen him sometime during my postgraduate days
Sometimes
and thereafter here.
Sometimes we read at home also.
I read. I say that I read and I have been reading.
Yes. Next. 26.
I'm for the respondent.
Respondent. Mr. Naik, you're for petition. Why are you surprised? Yeah, you see appearing for you.
Maybe there is some.
No, so many occasions he did not appear. I thought.
And you should be happy that today he is.
No, only last occasion I didn't this year. And subsequently I informed your lordship that missed the leave.
All right, what is this?
The last occasion, lordship was pleased to direct the state at the last heard to obtain instruction whether
Yes.
this case is pending or not. So my knowledge it came, lordship it is still pending,
Yes.
nothing has
1 minute.
moved.
I have asked there is a letter.
The matter state, so far as my knowledge.
I got a report. Case was filed on 2011. It's pending.
Yes, ma'am. Pending because they have obtained a stay.
It's surprise. See 143 and 148 of NI Act was in fact amended with the view that in the interregnum the complainant should get something.
Yeah.
But for the non compliance of 143, 148 and all, the proceedings are getting.
Yes, my lord.
It is from 2023 to 2026. There is some order passed under 143A for payment of some amount.
They have challenged.
For compliance, it is pending.
They have challenged this.
I have not received the penny. That
My lord, we have deposited the amount.
lordship kindly
Let us see what is the complaint is about.
lordship.
You are challenging what?
Lordship, my prayer is in the
Enhance the interim compensation
Last.
20%.
that is what from 1% to 20%. This NI court has awarded 1%. Now I have come before I have
That 1% also you have not got.
I have till now I have not.
We have deposited on the.
Kindly, about the boss.
Let me clarify.
Have you deposited?
Yes, on the next date I have deposited.
How much? How much?
Same amount with draft I have deposited, my lord.
Not telling these.
That is in the case record.
1%.
Yes, my lord. Draft
That's it.
45,000.
45,000.
45 lakhs, 1% awarded, 45,000.
45 are deposited in the court.
Yes.
On the next date itself.
Yes. Anything to say?
That's it.
I'll enhance little bit and finish it up. Okay. I'll pass it.
Milord, I have a say in this case. Milord, since from the beginning, our pleading is that the check is neither signed by me, not filled by me. These are fraudulently obtained by the complainant. And what he has done, because of his prior relation, because he deems to be a doctor to me, I was going in a pretense that he is a diabetologist and I am going. But subsequently came to know he is not a diabetologist even. He is not a diabetologist even. He is that RMP kind of practice he is doing.
That's the difference.
That is.
Have you issued the check or not?
No, I have not issued. I forgot the check in the on his table. Thereafter, this dispute.
You have received the notice, legal notice?
Yes, Milord, legal notice I have not received. What happened? I have taken entire plea to that effect because they have sent the legal notice. That legal notice delivered to the watchman of the building. That I could not receive in time. But when I knew that this case is pending, immediately I came. I approached the honorable court and I surrendered and released on bail, Milord. And thereafter, after going through the case record only, at the first instance, the 143 application was rejected by the honorable court. Going through the case records and materials on the record. Thereafter, they came to this honorable court, taken another chance to file a fresh petition.
Now it is an evidence stage. It will be a.
It is evidence stage. Let be clear, within 1 or 2 months, we have no objection. But 45 lakh they made a check, they filled a amount 45 lakh, which is beyond, far beyond my capacity.
What are you doing? What are you doing?
They are saying they are, I am trying to make a brick factory, Milord, at Berhampur. I am trying to do that. But that check is not, they are saying I have a business relationship with them. They could not establish in what manner they paid me money to me also. And the period they are saying that is a COVID period, that is post demonetization period. So that is not possible at all.
Those things are
trial. That is why with full satisfaction, Honorable Trial Court in session has rejected the prayer of the complainant, petitioner in this case, at the first instance. Thereafter, they came to approach this honorable court, made a prayer that I will make a fresh prayer. There again fresh prayer they made, so the honorable trial court, of course a different magistrate, they passed an order, awarding only 1%, so that his expenses of the litigation can be beared.
I'll pass you.
But I will be highly prejudiced if the amount. I have already made it.
I'll see. Whatever is the best, I'll do.
Let's see. Only thing to his answer I am adding. He's the managing director of private company, namely Porita and Sons Project, having its heads office. Now he says he has got rice mill business and a crusher industry. Lordship.
No.
This is at page.
They have not established.
Page 11.
It is their pleading, but they have not established any business transaction.
See,
Milord, my business is
not all these things. See, now it is.
45 ଲକ୍ଷ ଛୋଟ amount is ଅଲଗା କଥା 45 ଲକ୍ଷର 20% 9 ଲକ୍ଷ ହେଇଗଲା. Even 9 lakh is very difficult for me. I am never dealing with such huge amount. ସିଏ କହୁଛନ୍ତି ମିଲର ସିଏ ଯୋଉଟା କହୁଛନ୍ତି ସିଏ ଦିଟା ଜିନିଷ ଏବେ ଯାଏ ପ୍ରୁଭ୍ କରିପାରୁନାହାନ୍ତି ଯେ neither earlier nor after I had any written business transaction with you. ତାପରେ ଯୋଉ amount ଟା ଦେଇଛନ୍ତି କେମିତି ଆମକୁ ଦେଇଛନ୍ତି that କୋଭିଡ ପିରିୟଡରେ ସେ ଯୋଉ ଆମର ଡିମୋନେଟାଇଜେସନ ପିରିୟଡରେ ଦେଇଛନ୍ତି. It is very difficult. ଗୋଟେ ପଇସା ନାହିଁ ସେଠି ପଇସା କେମିତି ଦେଲେ 40 ଲକ୍ଷ ଦେଇଛନ୍ତି ଆପଣ ଚୋରେଇଥିବେ କଣ କରିଥିବେ ସେଇଟା ଆପଣ କ୍ଲାଏଣ୍ଟ ଜାଣିଥିବେ.
Yes, next. 27.
May I please? The order taking cognizance Jankan.
Pass over, Your Lordship.
Pass.
On behalf of informant, Your Lordship, pass over.
Next.
God
28.
bless.
Maybe next week.
It is in the weekly list. If you it will be taken up Thursday, no problem.
One.
Yes.
First. One.
Yes.
Problem.
28. 28.
Complaint case was dismissed for default. Notice was issued to the opposite party. On the date.
Service is complete. This thing. It is sufficient.
Challenge order on the annex of 2 miles. Which is dismissed for default due to not taking steps on the date fixed.
The complaint case.
My complaint case check bounce.
Show me the order. Dismissing.
Your Lordship page.
Where is
It
that?
starts from page 13, my lord.
At what stage it was dismissed?
Dismissed, keeping in mind, Your Lordship, page 16, I'm operating part. 16.
Yes.
Keeping in mind.
In your Lordship, Mr. Mahapatra was supposed to appear for opposite party matter. In fact, today is his brother's marriage. He is out. Yes. Next week, and
Let it remain. Yes. Let it remain in the list.
my lord, in fact,
We'll see you.
till Friday, he will be not available.
Thursday we'll see you. I'll recommend it. Don't worry. Yes. Next.
Opposite party may led by the complainant in the court below. As an expert, I have filed in a opposite party may led by the complainant in the court below. As an expert, I have filed in a substitution petition. Last occasion, I also sub copy.
Who died?
The complainant in the court below, not the opposite party in the revision.
Opposite part.
That's the last order. Last order, I have also sub copy.
Yeah. Person to the order. It is there. Opposing? Are you opposing?
No limitation bits are there.
The limitation
And when he died, let us see.
21 man. With the
21.
29th December 2021.
You are seek for it. But is not delay. Without that, how can it be?
Direct, I'll file one.
Why should I direct? It is your
criminal
file or don't
file. The criminal case, for that reason, I will file. Substitution, there is no provision.
I'll just take it up next Tuesday. Meanwhile, whatever you want to do it.
Yes.
Next Tuesday.
Yes.
Yes. 32. 32. Are you there in 32?
No.
Yes. Order should be. Yes. Next. 33.
My lord, as directed for conciliation.
Yes.
My lord, in train has submitted the report. Not submit anything.
Yes. Mr. Naik, yes.
I have submitted the report.
The report, my lord, that
As you file a report.
lady received the amount and served an affidavit there. And my lord, you can also tag this said affidavit in the report itself.
First, I issued a letter. Pursuant to that letter, counsel for the complainant remained present, but the complainant did not. On the date of mediation, the accused produced a affidavit that in pursuant to direction of this honorable court, previous order, the matter has already been settled and complainant has received all the amount. In that respect, he has filed a affidavit. Okay.
Okay. Vaishnav Charan Jena. You are appearing for the petitioner.
I am petitioner.
In view of this mediation report, we will dispose it up. What do you say? In view of
The counsel for the complainant, he disputed the signature. Well, that I cannot.
Disputed signature in the affidavit?
In the affidavit.
That's why she sought for an instruction.
My report is not there.
This is 33 item. Note.
33.
Noting the record.
What is the amount?
1,50,000 compensation 3 lakhs.
Who is appearing then? If nobody comes, then I'll. Who is
Namita Patnaik.
Namita Patnaik. You just pass it over, let's see if she comes.
Next sitting mirror on second.
I'll dispose it up today itself if you see. Call us if you see there. Otherwise, I'll take it up for Tuesday. Thursday. Okay. I'll dispose it up in terms of that. We can't wait.
Yes, madam.
And this affidavit, affidavit executed before the
Executive magistrate.
Executive magistrate.
Yes.
Yes.
Executive magistrate. This is let us see the Vokalatnama. Signature is also
Not a noting. Executive magistrate.
signature also looks like same signature.
Yes, same matter.
Same signature. Just see the signature in the Vokalatnama. You can see the same signature. We can't enter into this, an inquiry or.
But the complainant also did not cooperate with the mediation proceedings. He did not appear. Even if assured to appear, but on the date of mediation, he did not.
Did not come. Right on. Dispose up for them. If nobody comes, right up. When the this revision petition is filed against what? Which order? Judgment decree.
Against
You have been convicted.
6/10/2007.
Convicted. The conviction order is 10/4/2006 and 6/10/2007. When the affidavit was given, according to you?
Affidavit in response to the order of this report, that is 12/4/2023.
12/4?
Yes. Affidavit was made on
4/9/2023.
23.
Was there any order to that effect?
That prior to that one order, that is 12/4/2023, order
Yes.
number 18.
Yes.
was made and that was also reflected in the order affidavit itself. As per the order passed by this honorable dated 12/4/23, I have received full and final amount from Chandrasekhar Kumar and an amicable settlement took place between us out of the court. Hence, I do not want to proceed further. Order number 18, my lord, please.
Yes. The counsel for both the parties shall obtain instruction regarding the amicable settlement of the dispute between the parties and the amount to be paid by the district. And thereafter, this settlement has taken place.
Yes.
Okay. Okay, I'll pass the order. Okay. Then, okay. Next. 34.
Yeah, for my lord. I am for the petitioner. The petition, take amount is 20,000. Petitioner is willing to settlement. Several times matter was listed before local government. For accused, nobody is appearing. That's why on 9/5/2024, order was passed. Lordship kind of glance. 9/5/2026.
Nobody is appearing.
Nobody is appearing, nobody is present.
20,000.
Yes.
You are ready to?
Yes, yes. This petitioner is now suffering so many diseases. Therefore, he is not interested to.
He is convicted, huh?
Why not?
He has been convicted.
Yes. SI for 1 year.
You deposit 20,000 here?
Yes, your lordship. In the name of the accused.
No, before register.
Yes, your lordship.
As and when it comes, it
Yes,
will be invested.
your lordship, and direct, I will deposit. 2 weeks timing granted.
2 weeks, huh? Where is the check amount? Let us see.
20,000. Lordship, kind of glance annexed 1.
This is the
Page
magistrate's
8.
order, huh?
Page
By the judgment dated.
Annexure 2, page 14,
Okay.
lower court order.
By judgment dated to 20th May 2008, the petitioner has been convicted by the court of JMFC Jaipur for offense under section 138 NA for prisoner of check of rupees 20,000 in 1 CC case number 121 of 2006. 2006 and 2006 Kulta. He was sentenced to undergo SI for 1 year and was also directed to pay compensation for rupees compensation of rupees 20,000 to the complainant public respondent. The said judgment of conviction and order of sentence was essayed by the petitioner before the court of additional sessions fast track in criminal appeal number 58 of 2008. The first appellate court, by its judgment dated 24/3/2009, upheld the judgment of conviction and order of sentence passed by the learned GMFC. Hence, this criminal breach. The matter was heard many times by this court and eventually placed before Mr. Logan. Placed before Mr. Logan. But the respondent, the complainant, did not participate in the proceedings. Let counsel for the petitioner submits that his client is ready and willing to make good the entire check amount. However, due to non-appearance of the complainant of the respondent, the same could not be made over to him. When the matter was taken up made over to him. In view of the considered, in view of the statement made by the counsel for the petitioner and the respondent of the complainant Senate in the present proceeding since last many did up to we intend to dispose of the criminal the director to the petitioner to or this was it, the 25,000, this was it, the compensation amount of 25,000 as has been allotted by the courts below. Before this court, before this court, within a period of
15 days.
15. The amount to be distributed by the petitioners and the resistance and investors, the interest bearing account, put it in the interest bearing account, and liberty is granted to
We have bank draft. Bank draft.
The liberty granted to the respondent to move the appropriate application for the release of the same. So the same in view of the aforementioned direction, the judgment and order dated 48.8 and 24 passed by it stands satisfied and please. What's next?
35.
Yes, satisfied. Yes.
36.
May I please, Your Lordship?
Yes.
My Lord, by the order dated 18/5/2026, I am directed to deposit 50,000.
18/5?
26. Last order.
Yes.
I am directed to deposit 50,000 rupees, my Lord. But when my Lord, the matter arising out of from JMFC court. So,
yes.
I went to JMFC Bhubaneswar, but that court does not function. And I file a memo stating therein that for I may be permitted to deposit the amount. The file was not pressed out.
Compensation amount is 75,000. 75,000 was the compensation.
Yes, and
25,000 rupees you have already deposited.
Yes, my lord.
And
Not before this court, but wrongly, it has inadvertently mentioned that has been deposited before the JMFC Bhubaneswar as per direction of this court.
Okay.
Now, because due to non-availability of the court, so he approached the SDJM. He said that case has been disposed of unless the direction be issued by this court for extending time. We are not accepting. So my learned friend is appearing. I may be permitted to give a bank draft in favor of the opposite party. So that will solve.
Give it.
Yes, my lord.
Come on Thursday.
My lord.
Come with the draft. Give it.
Yes.
Thursday.
Next week, your lordship.
Thursday you come with the draft.
Next.
Thursday, day
Yes,
after
yes,
tomorrow.
ma'am.
You
Okay.
come with the draft, you give it and I'll dispose it up.
Yes, man.
Okay.
Obliged.
Okay, come with that. Let him come on Thursday, you take the money and finish it up. Okay. Thursday.
37.
Item 37, I am for the opposite party, Lordship.
Yes.
That's the last officer.
Substitution not filed by the opposite party. Last occasion, they are received direct to file substitution. Yet he has not filed a substitution.
Yes.
Is it 2 weeks time to file?
What 2 weeks time with this? The complaint case is pending since, let us see, this revision complaint
14.
case is 2011. And the appeal is up to 2009.
9.
Are you interested to prosecute or not?
Yes, Lordship.
What is the check amount?
1,41,537. Compensation
interested?
amount 1,07,000.
The last order just read.
Yes. 21 first, 22.
Gopal Krishna Sahu and another.
Yes.
Who has died?
Gopal Krishna sir.
When he has died?
There is no instruction, Lordship. Yes, the petition has submitted in that way. Lordship. Yes, yeah.
Why have you not moved the application?
Yes, he contacted was petitioner as a complainer has not come.
2014 matter. Thursday you do it, otherwise I'll do it. Allow you. I'll allow it. I will not do it.
It's 1 week time, Lordship.
No,
contact
no.
with the
whole, see, this order was passed on May 2026. Today we are in June. Why 1 week? Thursday.
Maybe
Next.
last chance.
Thursday. Let it remain. Otherwise, I will allow. I'll set aside the conviction and finish up. Yes. Next.
38.
Make it short.
Consolidate the amendment application allowed. Consolidated cost detail always filed, my lord. That may kindly be accepted.
Who died?
My lord, the complainant
Complainant
died.
Yes. Substitution allowed.
Substitution allowed. Consolidated cost detail file that may
Yes.
kindly be accepted.
What is the amount? What is the
In first matter, my
My lord,
lord,
there are good terms. But
how
there
many
are
matters? There are 2 matters.
three matters.
Three
Three
matters.
matters.
Yes.
Well, total my lord, check amount is 11 lakh some odd. my lord. And
Total amount.
Total amount.
Yes.
And my lord,
In
entire
all the
amount-
three.
Yes, 3
Yes.
million. The entire my lord, amount will be settlement. Usme glad me as a 1 month time. My lord, amount will be clear.
my lord, kindly have a glance to the order dated 6/12/2016, order number 15.
One law is
6/12/2016, order number 15.
Yes. In view of
By
I was
in
modified
view of
one
the
law
order
directed
passed today in Miss Case number so and so, let the counsel for the petitioner doesn't want to press the Miss Case. Yes.
No, director, my lord.
You are reading that. Oh,
Order number 15.
50.
Considering the submission made by the counsel for the parties, it is directed that deposit of 1 lakh rupees,
Yes. Petitioner
within a period of 2 weeks, hence realization of the balance will complete.
till date the petitioner
Has not paid. That amount has not been paid.
till date.
Yep.
So I say I'm gonna submit my lord. Entire amount will be settled, my lord.
First you pay that 3
No,
lakhs.
So 2016,
That-
Double
10
ହେଇଯିବ
years,
କଥା।
That I know.
ବ୍ୟାଙ୍କ ରଖିଥିଲେ ଡବଲ ହେଇଯାଇଥାନ୍ତା।
That-
10 years ଡବଲ ହେଇ
you show your bona fide. Come on Thursday. Come with money.
At least 1
Show the color of the money.
One-
to him.
At least
No, I will hold it like this only. It will not be taken out of the board. You come, show the color of the money to him, and he may be.
That's not the I will not be able to.
16. See,
And that I will. That I
10
can't.
years.
That is there. my lord.
10 years.
next
Thursday.
my lord, next week.
Next week.
Thursday,
I will available.
next week.
Tuesday. Next Tuesday, come with the money. Come with the money. Whatever money you want.
The 3 lakhs my lord I will give.
3 lakhs, 4 lakhs, whatever.
That is there in the order, my lord. So good.
Whatever. The 3 matters, 3 lakhs.
Yes.
3 matters, 3 lakhs, then we'll see
Yes,
what
my
can
lord.
be done.
Yes.
Okay.
But On Thursday, next.
And the total amount is 11 lakh.
Yes.
11 lakh 50,000.
50,000.
That was settled between the parties.
You will be happy with 11 lakhs or
that was
now?
11 lakh 50. Bank interest, and I will convince them to get that principal amount, check amount.
Principal amount, any case you are getting.
Yes, that
11
is
lakhs
getting.
50,000. I'll
In
try to convince.
that between it will settle.
If the petitioner will pay the 3 lakhs,
I'll pay. That no issue. I'll pay. Then
I am sure I will 100% convince the son of the complainant to satisfy with that 11 lakh 50,000.
Call your client here.
Yes, correct.
Tuesday. Let them personally present.
Both the side.
Yes.
So,
Because he'll bring with money, you have to
Yes.
pass on.
yes, well, him there. Yes.
Let the parties present on next week. Huh?
Ledger and accused will produce 3 lakhs.
3
That
lakhs.
is.
Well, draft will come.
3 lakhs. Huh? 3 lakhs. I will not say anything to the respondent, na? Petitioner.
Petition.
The petitioner shall demonstrate his bona fide by at least by complying the direction made by this court on 6/12/2015.
8 Thursday next.
Thursday, yes. 8. No, that is
It takes some time.
On
7.
7th.
No.
Mangala Guru they didn't.
Guru. No rest. 9th.
Gurubar का तुम पैसा दो बनी.
Some listen. Listen again to you. I'm sure that will come with me.
Thursday I will not pay. Let it be clear. Okay.
39.
May leadership law 39 million the case of hypothetical in a 138 order. And I am praying this Friday Miller.
Be
happy
happy now. You are complaining.
Complain more 16 lakh taka budi gala ticket is.
You will not file recovery suit.
The suit file
No, why it is?
Because
Why
Miller-
it is executed? Generally, equitable orders are not passed in 130. There must be.
खाली गुरुवार को रही था वो आउट ही है.
Let it remain. Huh?
हाँ ये वीक था वो
Okay.
पास.
Yes.
One more prayer Miller. Item 17 Miller और bail और
Thursday.
17 modification ना मु custody रह गया कि bail है.
Thursday, no problem. Thursday, I'll take it. Day after, it will remain in the board.
हाँ
Thursday, you come.
गुरुवार को.
Next.
गुरुवार को.
Guruvar.
40.
Guruvar. Thursday,
Already.
Already order. Arjun kar. कौन करें? Arjun kar. Supplementary नहीं से गुरुवार को.
मॉडिफिकेशन ମୁଁ ମାସେ କାଳ ଜେଲରେ ରହିଗଲି ଟିକେ ମଡିଫିକେସନ.
यदि ऑर्डर है ना तो सप्लीमेंट्री कर दियो ठीक है. Yes.
Item 40.
May I please, your lord. Sir, I am from the petitioner, your lordship. Yes, out of 2 lakh, he has paid 1 lakh, and rest amount so far is recent instruction I could not receive, your lordship.
Who is appearing for respondent? Check amount is only 2 lakh rupees.
Mal-
Check amount is 2 lakh.
Check amount to 1 lakh.
1 lakh 50 and okay, 2 lakh is compensation and all. Huh?
Mal-
Okay. You deposited.
1 lakh I have deposited before trial court, and he has received.
The remaining 1 lakh?
Mal-
Thursday you deposit here. I'll dispose it. Thursday. Come with 1 lakh rupees.
Mal-
Okay. Thursday. Yes.
41.
You come with the draft.
Mal-
Deposit here in the court. And I'll dispose it up. He'll take it up when apply will be up. Yes. Yes.
Here is a case. This minister was working in a company which exports prawn and with prawn export. He resigned from the company in the year 24 January and gave an email notice, and the notice period expired. Thereafter, he joined.
34 notice. 32 notice. Resign. You have given it, submitted before ROC.
No. I am an employee. I'm not. I was working as an employee.
Achha,
as chief-
not a director.
No director.
Yes, okay.
I was an employee as a chief operating officer and left the company by giving resignation and joined another company who also deals with the same
same promise. I resigned in 2024. In 25, my erstwhile
What's the
company,
date of resignation?
my resignation date is 7/1/24.
7/1/24.
The email was sent, resignation letter dated 2/1/24. That is Annexure 2 CD.
Annexure 2. Yes.
I was appointed in another company, that is Annexure 3, on 5/4/24. That is DNC Sales Annexure 3. Man. Now, my lord,
Appointed on 5/4/2024.
2024.
Annexure 2. Annexure 3. Okay.
Then, my lord, this when I joined the rival company in the month of January 25, the erstwhile company lost an FIR against me that in somewhere back in 21-22, some of the suppliers who supply the prawn to the company, they have purchased some huge amount of furniture from me. And nothing, no loss to the company. That is that, and the notice was issued by the IAC to appear before him. I approached this honorable court. This honorable court protected me that 41 and all this
Yes.
Immediately thereafter, on 18/1, he lost an FIR adding 420 and 409. So that it is 41 will not come. Then I approached this honorable court. I was under the protection. I am released on bail. And not at all, they did not stop there. They froze my account.
Yes.
That was also released by the ultimately when the police report was called for, they said now we don't require his account for us. They also released that. Now this case, Your Lordship, I am reading the FIR. How no offense is made out after plain reading of the FIR. No offense is made out.
Where is the FIR? Annexure?
Annexure 1.
Yes. What is the stage?
Yes, madam.
Interestingly, they have, Your Lordship, directed them to file an affidavit. They have filed.
Yes, we have filed the affidavit.
Explaining everything. And till now, those two persons alleging that they have purchased some materials for me, they have not been examined till. They say that only we have sent notice to them. That's all.
Yes.
I will also see the FIR. I am reading the FIR. We all wish to draw your kind attention of the fact that the Hon'Ble was working with us since last several years in responsible position. His last designation was Chief Operating Officer, and he was in charge of managing production in our factory and was also looking at the purchase of raw materials from various locations within state of Orissa as well as the other state like Andhra Pradesh. During course of income tax investigation in 23, his dealing with various suppliers was scrutinized. It was found that Hon'Ble is indulged in corrupt practice for his individual gain, causing loss to the company. While in employment, he found to have taken money from the company's suppliers, which was instructed them to make payment to various persons to discharge personal liability. Following instances came to our notice. During period from 21 November to March 22, Hon'Ble Pichai of Andhra Pradesh made a payment of 1.34 lakh to various parties such as Transformer Furnitures Limited, Karja Shopping Complex, and KK such and such. All these payments were made by Pillai at the instance of Padmanabhan sold for his sole benefit. That is they have made some purchase for me. Now, no loss, neither that is the money of the company nor any loss to the company. It is nothing to related with the company. But they have made some money, and also they have recorded statement of the furniture supplier. He also said that, I am reading his statement. He said
Let us complete.
Similarly, another supplier, BPS Hanuman, made a payment of 37 lakhs to various parties such as Transformer Furniture, such and such, for his personal benefit. After coming to light, we inferred these facts from the Padmanabhan, who did not accept them and abruptly resigned in March 24. And the facts narrated of supplier located in appearance that he must have done similar dealing with other suppliers. Our personal inquiry.
Yes.
Our personal inquiry. Also, apportioned supply reveals that the Parmanav was exerting undue influence upon the extract personal benefits for himself with the intent of cause wrongful loss to the company.
Yes.
This is the FIR, my lord.
Hmm.
What offense is, my lord? The offense they have alleged, my lord. That is 408, my lord. What the 408 says, my lord?
What is the stage of investigation?
That investigation is going on.
Going on means how many years it will go on?
My lord, they are spending the
Offense is not.
When was the FIR registered?
January 2025.
2025 or 26?
25.
24.
24 I resigned, man. 25. After 1 year they filed FIR. I resigned from their company in 24.
See the FIR number.
FIR
19
number
of
25, man.
19 of 25.
19 of 25.
Lakshmi Sagar year
Yes, ma'am.
2024.
18/1/25 the FIR was registered.
18/1.
25.
It is not legal at all. Anyway, yes.
And 409 you also know, 409 doesn't attract to these private companies, man. It is only public servant. I am not a public servant. So 409 is not made up. And 420, what I have not taken any property of the company, neither have dishonestly sold anyone to them, nothing. Nothing, man. It is no offense is made. It will squarely covers. I have given that lordship that judgment. The state of Haryana versus Bhajanlal, that paragraph 100. The judgment I have supplied to the lordship last.
Yes.
Paragraph 105. In backdrop of the interpretation of various relevant provisions of the court under the chapter 16, chapter 14, and the principle of law enacted in this court series of decisions relating to the exercise of the extraordinary power under Article 2.6 or the inherent power under 482, which we have extracted and reproduced here, we give the following categories of the cases by which the illustration where such power could be exercised either to prevent abuse of process of any court or otherwise to secure the ends of justice through its
That's right, but let us understand what have you got against him now?
There's some material there where I play some more time because of that is the
every time that they-
18C26.
What material you show me what material you
Yes,
have.
18C26, they are sent the letter to that two company from the Andhra, but they did not.
You place it on record, but what have you got against him?
Nothing.
And there is
no
there is
material.
a four one substance statement is with us, and the investigation is going on.
Who is the IO?
IU is the SI Lakshmi Sagar.
Let him appear online. That's it. Let us understand. Let me IO of the case. The period of police for. VC mode, let us understand from him. VC, let him come out. He will not come, just let me understand what exactly he is doing. Yes. That's it.
They are filing affidavit also court not.
But you see in the affidavit, there is nothing.
Nothing, man. No material, nothing.
Let him.
Man.
Huh? Okay, next. Wait. 15 minutes. Yes. Hearing also.
42.
That's it. Let the yes.
52 is an appeal
Yes.
against conviction under 161 IPC and 51D of the PC Act 47.
Yes.
Appellant is dead. Legal heirs are pursuing.
Okay. Let us proceed. If you are ready.
No, vigilance.
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 Who is appearing?
I believe Mr. Rizvi should be.
Will intimate after lunch.
After lunch, we'll see. 94 appeal.
Lunch period and I would.
And the principal accused has also died now. Any attachment, anything? Attachment? Only stigma?
Only stigma. 150 rupees was mandatory.
Call him, we'll finish it up only for stigma, I think. So, won't be,
There is.
much consequences. The man has already died. The children are fighting only to remove the stigma. Call him, we'll finish it up today. Okay.
42 to 45 siblings are there after my class.
Why didn't
42 to 45. Thursday.
call? Item 43. Yes, tell the court, not that we can submit it.
43, Lordship, I'm appearing on behalf of Mr. Moon. Lordship, I pray for the matter to be taken on Thursday. We are ready with the matter. A small written note is to be prepared. It's filed on Thursday. And I've spoken with Mr. Sarthak Naik. He's also ready. 43.
43.
Yes,
Okay, Thursday. 40.
44.
These are old matters, 99 matters. So therefore, yeah.
53, 44, 45, they're all ready, Lordship.
So I will not adjourn on Thursday.
Yes, Your Lordship. We are not adjourning it on Thursday. Today, sir is having some personal difficulties, so he's not there.
Okay, you come with your written note of submission and finish it up. Okay.
Yes.
Okay. All are connected matters or what? 43 to 45? Different matters?
Different matter.
Maybe connected also, the same, like maybe the co-accused person, I don't know. Anyway, let's see. Yes.
46.
It is vigilance. 47 also vigilance.
47.
All vigilance. But treasury is
Up to 47 vigilance. Up to 47.
all mixed treasury, yeah? All mixed treasury. 30?
47 vigilance.
And what about this 48?
To 47, that is a vigilance.
Let me
48 to normal.
48?
What is normal number?
No, we appearing 48. This is also 95 met. Huh?
Mr. SS, HS Mr.
Yes, 48. What do you? Why today 95 matter? Why this?
Sir will argue them.
You start. We'll see. After lunch, you start. Let us see what are the offenses.
376.
46, no?
48.
48, no? Let us see. $376. Who is going to argue?
Yes, my senior one.
Mr. Dhar.
Yes.
On him. Let it be there and this. Yes.
49.
There is a government appeal also.
Yes,
in,
ma'am.
48.
Yes, ma'am.
You're questioning what? What are you seeking? Well, the other co-accused person, those who have been acquitted,
Yes, ma'am.
for the 376,
that.
you have challenged that.
Yes, ma'am.
Secretary.
49.
49. Yes, 49.
Yeah, children should remember.
Against what? This is. Three and all, huh?
354, 327, 294.
Let's see what was his
Instruments. No. Not mentioned. Everyone we are picking.
who is the lawyer here? Let's just check it out. The vocal of law. He's vocal of law.
49 उसको मिलान करेंगे 49 इसको मिलान करेंगे पिटिशन में क्या चाहिए
इसके नेगेटिव
इसको नेक्स्ट में क्या चाहिए तो पिटिशन अपन को मिलान
Call him to. I'll do this. Yes. His name is reflecting here. Sure. Okay. It's number is this. Almost literally, this please become Pucci.
I'm for the respondent.
Okay.
Appellant fellows, and I don't know whether the respondent is still alive or not. It was a very small incident. This lady had come inside this man's mango grove, was taking away mangoes, so there was an altercation. So she filed a case under 354. My client was convicted by the magistrate, acquitted by the sessions. Then they came up in appeal before your lord. That is the entire case.
Who is appearing for the appellant?
That, my lord, who was appearing SK9. SK9, AK Acharya, KK Das, SM, S Man.
Mr. Mishra, I am requesting you to assist as a case. I'll put it next Tuesday. Mr. Mishra is appointed. Non-appeals continue.
My lords, 2 weeks, because I'll also have to reconstruct this file. And I'll also take instructions.
Take in the pen.
Yes, ma'am. And I'll also have to take instruction whether this person is alive or not. 30 years have passed in the meantime, ma'am.
So meanwhile, you get it 1 week after, yeah? That's one. Correct.
All right.
Yes. Person Kumar is responsible. Am I case? Yes. Huh? Two and a half months. 24 kada? 74. 71 kardi. Period undergone is 2 months.
2 months, 19 days. He was arrested on 31/1/2004.
31?
1/2004.
Yes.
Then released on bail on 19/4/2004.
19/4/2004.
307 was initially there. That there he has been acquitted. 307 has not been believed by the court. It is only under section 344 conviction is there. 2 years below.
Okay.
That is
Okay. Yes.
I mean, pardon to mention.
Yes.
After telling the board today, that was heard by your lordship extensively. And on my request, your lordship was pleased to keep the matter for further hearing. I will not take much time, only 5 minutes I will complete, because all the facts were narrated in the written note supported by the judgment clause.
When do you want? Thursday? Thursday?
Now.
Now I fixed one matter.
Oh.
Thursday anytime you can come. Thursday morning hour also you can come. Because the argument is already concluded.
Just I requested your lordship and your lordship.
That is the reason. That's the reason. Mr. I think Mr. Devasnan Mishra. Yes, sir. Yes, 42. Yes, 42. File the thing.
Please, my lord.
Yes.
Apologies for my absence during the first call, my lords.
Yes. The appellant has died, and now the LRs are contesting.
Yes.
To remove the stigma.
Yes.
Yes.
Is your lordship. deceased appellant, Bimbadar Mahanti Malats, was found guilty on sections 161 and 512 of the PC Act 1947. And he has been sentenced to undergo imprisonment of 1 year and fine of rupees 500. For the offence under 5.2 read with 5.1d, no separate sentence has been passed under 161 IPC. Now the prosecution allegation is PW1, who is the decoy, is the informant, and he has lodged an FIR saying that he had approached the deceased appellant, who was OIC of Gochapada PSV Lords, to interfere in connection with a dispute between him and his father, Milords, for which a bribe of rupees 500 was demanded, which was scaled down to rupees 300, and he had paid 150 rupees earlier. And since the accused demanded rupees, the balance 150, which he was unwilling to pay, he complained before the vigilance. Now a trap was set, my lords, and the bribe was delivered, and thereafter, my lords, the investigation concluded in a charge sheet against the appellant.
Yes.
At the trial, my lords, however, the overhearing witness could not be examined because he was dead. So the sole evidence of the decoy with regard to demand and acceptance, my lords, is the basis for the conviction. Now, so far as PW1 is concerned,
let us read PW1 full.
Yes.
Yes. Page 52. Yes.
The relevant paragraph is paragraph 7, so far as demand and acceptance. I'm placing it. 52, he says, I know the accused present in the dock today. He was officer in charge, Gochapada PS. My father is Alif, has 2 wives. My mother is the first wife of my father. As there was a quarrel between my mother and stepmother, my father asked my mother to stay at Kamtana in separate mess, gave her 6 plots of land, a pair of buffaloes, and some seeds to start cultivation. Accordingly, I, along with my mother and my younger brother, left for Kamtana and maintained house. 3 years after separation, my father lodged information at Gochapada PS against me and my younger brother, alleging theft of the said pair of buffaloes. Accused called me and my brother to the police station. At the police station, he asked us if we had stolen a pair of buffaloes of my father. We denied to have committed theft of the buffaloes, but we returned the pair of buffaloes which were given to us as my father had lost the information against us, alleging theft. When we returned the buffaloes, my father asked us not to cultivate the land which had been given to us. We asked the accused how we will maintain us if we would be deprived of the land where we had raised crops. Accused told us to lodge a report. Accordingly, I lodged a report. Accused told me that he would take action on the report only if I would give him 500 rupees and demanded that amount. I requested him to reduce the demand to rupees 100, stating about my poverty, but accused told to give at least 300. I told him that I would give him the money after my matter is settled, but he demanded rupees 150 at the first instance. As accused insisted for payment of money, I agreed to pay the same after arranging the same. 5 to 6 days thereafter, my mother brought rupees 150 from my father's house. I took that money from my mother and going to Gochapada gave the same to the accused. Accused on receiving rupees 150 inquired for the balance, told me to give the balance, So I returned back to my village, sold one of my she goats for rupees 160. As the accused demanded money, I thought it proper to come to Berhampur and lodged information with the vigilance officer instead of going to the accused and paying money to him. So I came to the vigilance officer at Berhampur and narrated about the incident orally to the officer. Vigilance officer asked me to report in writing. So I wrote a report, submitted it to the vigilance officer. This is the report exhibit 1 by 1 is missing. Thereafter, I, along with the vigilance staff, proceeded to Fulbani. On our way to Fulbani, we stayed at G. Udayagiri. Next morning, we proceeded to Fulbani, went to the IB. There, the vigilance officer asked me to produce money, which I arranged to give to the accused. I produced rupees 150, which I had with me, consisting of one currency note of 100 rupee denomination, two currency notes of 20 rupee denomination, one currency note of 10 rupee denomination before the vigilance officer. He again returned back the money to me, asked me to count the same, which I did, and also found that the money consisted of the currency notes of the denomination described above, amounting to 150. Thereafter, vigilance officer asked me to wash my hands with some water which they had. I washed my hands with that water, but color of the water did not change. Thereafter, some white powder was smeared on those notes. Again, I was asked to count those currency notes. Again, I counted the same. After the counting was over, I was again asked to wash my hands with some water which they had. This time, the water changed its color and became pink. It was kept in a clean bottle and was sealed in my presence. Thereafter, one of the officers present there put his initial on those currency notes. Vigilance officer also prepared some documents. I was asked to put my signature there. Exhibit 2 is one of those signatures. From Fulbani IB, I, along with the vigilance and Boroju Digal of my village, went on a jeep to go.
He was examined?
No, Boroju is dead by that time. We went to the lamps office, which is in front of the police station, where the raiding party remained. From the office, I and Boroju went to the police station. On our arrival there, we found the accused absent. Petition writer was present there, inquired from him about the accused. Maliram told, informing that the accused had gone to market and would be back within a short time. I and Boroju sat on a bench that was on the Thana veranda and waited for the accused to come. Sometime thereafter, the accused arrived, inquired from me if I had brought the money, and sat on a chair which was on the ground near us. Then he demanded the money. So I gave him that, and on receiving the same, he counted the same and gave in his chest pocket of his shirt. Now, so far as demand is concerned, my lords, this is the solitary sentence on which the prosecution case has to demand. Yes. That the accused arrived and inquired from me, if I had brought the money, sat on a chair which was on the veranda near us. Then he demanded the money, so I gave him that. 8 ounces. When he received the money, Boroju Digal went to inform the officer, vigilance officer, as was instructed by them. The vigilance officer and others came in 3 groups from 3 directions and got hold of the accused. Officers asked me whether I had given money to the accused. I answered in the affirmative. Some of the officers asked the accused if he had received rupees 150 from me. Accused denied to have received the same from me. So the vigilance officer washed the hands of the accused with the water which they had taken, and the color of the water became pink. That color was kept in a clean bottle, was sealed in my presence. Accused was asked to take off his shirt, and when he took off the shirt, pocket of the shirt was washed with the water, the color of which became pink. That colored water was kept in a clean bottle and was sealed in my presence. one so and so of Gochapada came to the police station. He was asked to count the currency note recovered from the pocket of the accused, and when he counted, his hands were also washed with water, which became pink. That colored water was also kept in a clean bottle, sealed in my presence. Thereafter, vigilance officers prepared the documents. I put my signature on one of those documents, that is the detection report. Copy was given to the accused. This is my signature, Exhibit 6. IO seized the currency notes recovered from the accused. So what he says, my lords, is that after that solution, color of the solution changed, when Mishra of Gochapada came to the police station, who was asked to count the currency notes, which were recovered from the pocket of the accused, and when he counted, hands were also washed with water that became pink. That colored water was kept in a clean bottle.
Mishra was examined?
Mishra has not been examined. Now, in cross-examination, your Lordship may see paragraph 9. I have read up to class 3. I do not know English. When I reported the matter to the vigilance officer at Berhampur, he scribed the same and handed over his writing to me, asking me to copy out that writing in another paper. I cannot say how many days after the return of the buffaloes or the date on which I came to Berhampur to lodge information with the vigilance officer. The day on which my father received back buffaloes also told us not to go over the land. On that day, I did not lodge any information at the police station. On the next day, I went to the police station, complained that my father was not giving any share of paddy. 6 to 7 days after that, I gave rupees 150 to the accused. I did not tell anybody that the accused was demanding money. By the time I lodged information at the police station, paddy on our land was ready for harvesting. On receiving my report, accused forbade both sides to go over the land and to harvest the crops, and posted a constable to watch and prevent my mother about the demand made by the accused. 5 to 6 days thereafter, she went to her parents' house and brought the money. She brought the money from Sebak on her. I could not have paid anything if my mother would not have brought money from her. Baraja Digal was a member of my village who is now dead. I went to the police station with Baraja to pay money to the accused. I do not know if Baraja Digal deals with wooden planks. I do not know if Baraja Digal had taken money from the accused to supply him with planks. I do not know if Baraja Digal supplied planks worth rupees 50 and he did not supply the planks for the balance or was to return the money. It was a defense plea that Baraja Digal was a dealer of wooden planks and he had taken money for supply of planks to me, and since he did not supply the planks, he had agreed to return that advance of 150 which he had paid. This is my defense plea.
Baraja Digal paid. How the accused has come?
My submission, my lord, says that so far as the recovery is concerned, I took the plea that that money was not handed over to me by the accused, but it was handed over to me by Baraja Digal, who could not be examined because he was dead by then.
No, how it has gone to the accused's pocket?
He has paid it. Baraja has paid me and it has gone to my pocket. That's what my plea is.
Why Baraja has paid it to you?
And same tainted and the same tainted GC notes.
No, 313.
Tainted GC notes ke mone korchi.
Come to 313, last question.
Page 44. I have taken that.
He has given a very long explanation.
Yes, page 44.
Question number 20.
Last question.
49.
Page 50. 49 it starts.
Yes. What is this?
Answer, Baraja Digal had taken 300 from me for supply of wood. He had supplied me wood worth rupees 150. He did not return the balance amount of 150. On 10/11/86 at about 5 p.m., Baraja Digal came to PS for return of 150 due to me. He gave me rupees 150. I received the money kept in my chest pocket
Of the
of the shirt. That money was seized. I asked them to wash the hand of Baraja Digal, but it was not done. Baraja Digal has falsely implicated me in this case, as I asked him to return the balance amount of 150. I do not know PW1. He had come only once to lodge a report. I have not seen him thereafter. Vigilance officers have foisted a false case against me. This entire...
Because Boris Digal died, so therefore it was easy for you to...
I do not know whether Boris Digal died or not. How do I know, Miller?
You in the cross-examination it has come.
Chief re aschi. Cross re aschi. PW1 chief re koichi pura.
You read chief or...
Chief re koichi. Page 6, page 57 है देखो तू.
Para 9.
50?
57.
Oh, that is in chief. Okay.
Alles. Page 57. Last but one para.
Good minute.
Last 3 lines. Boris Digal was a member of my village, is now dead.
এটা cross require.
Come in cross.
Cross.
Para 9 ରେ କୁହାଯାଇଛି, I do not know if Baraja Digal deals with wooden plank. I do not know if Baraja Digal ବାକି erase ହେଇଯାଇଛି from the accused to supply him planks. I do not know if he has supplied planks worth rupees 150 and he did not supply planks or was to return. Cross examination para 11 देखो.
Yes.
मैं para 10 रा last line देखो. The crop was kept under the receivership of Baraja Digal, the ward member.
Yes. Is how the trial court deals with the self-defense.
ତାପରେ ଆଉ ଗୋଟେ ସେଣ୍ଟେନ୍ସ ଦେଖନ୍ତୁ ପାରା 11 ପାରା 11 ସେ କହିଲା 5th line, it is not a fact that I did not state in my report or before the police that I sold one of my she goats for rupees 160. जो चीफ रे कहला 160 टंका छेली मारिकी बिकी देता एटा एफआईआर रे नहीं किंबा स्टेटमेंट रे नहीं. तापर देखंतु पैरा 12 रे देखंतु, when I complained before Baraja Digal that the accused was not settling the matter despite payment of rupees 150 and was demanding rupees 150 more, Baraja advised me to go to Berhampur and lodge information with the vigilance officer. So I came to Berhampur with Baraja Digal. When I paid rupees 150 for the first time to the accused, Baraja was with me. Before selling the goat, I also consulted Baraja, who advised me to sell the goat and arrange the money. When I came to Berhampur, I had with me rupees 150 only. The expenses were borne by Baraja Digal. It is not a fact that Baraja took that 150 from me on our way to Gochapada. It is not a fact that Baraja gave that rupees 150 to the accused towards his balance amount, which he received from the accused to supply planks. When we arrived at the police station, there was no police personnel present there.
Then let us see the other evidence, whether the money is given by Baraj or the PW1.
And there is no other evidence.
Because overhearing witness has died.
No, Baraj Digal died.
Yes.
But the question is whether the money, if the money is paid by Baraj Digal to the accused, then his defense is correct. if Bharat Digal has not paid, rather the PW1 has paid,
Yes.
then the story is different.
ସେଇଟା କିଏ କହିପାରିବ? ଆଇଦର ମାଳିରାମ ଯଦି ଏକ୍ସାମିନ ହେଇଥାନ୍ତା ସେ
Maliram is not
କହିଥାନ୍ତା
examined.
ହି ହାଜ ନଟ୍ ବିନ୍
Who else
ଏକ୍ସାମିନ।
is there?
ତାପରେ ଦେଖନ୍ତୁ
Reading party.
PW1 କହିଛି ମିଶ୍ର ଆସିଲା, ମିଶ୍ର ଆଗରେ
Misra is
ଗଣତି
not
ହେଲା,
examined.
ମିଶ୍ର ହାଜ ନଟ୍ ବିନ୍ ଏକ୍ସାମିନ। TLO ଏକ୍ସାମିନ ହେଇଛି, TLO ବି ସେ କଥା କହିନି। ଆଉ ଯିଏ ମାଜିଷ୍ଟେରିଆଲ ୱିଟନେସ୍ ଯିଏ ଆସିଛି PW2, his name is not Mishra, he is T. Surjanarayan, and he has not spoken about demand at all or acceptance because he has come after that. Kindly look at the evidence of PW2.
No, he has told about the demand part. Page
Yes,
60.
what was that?
Page 60. PW2.
ଡିମାଣ୍ଡଟା କୋଉଠି ହୁଏ? ଯଦି ସରକାରୀ ଓକିଲ କହିବେ ଯେ ଏଇଟା ଡିମାଣ୍ଡ, ତାହେଲେ ମୁଁ କହିପାରିବିନି। ମୁଁ ଜାଣିବାରେ the version of the decoy is to be corroborated by the overhearing witness. Overhearing witness is required to corroborate. Why? Because the decoy's evidence is always deemed to be suspect.
Yes.
That is the prima facie view of law. Now look at PW2 what he says. Let us accept, let us read that page 60 also, and let my learned friend be satisfied. He says, out of those, I am placing 4 lines from the bottom. I found the vigilance staff and 2 other civilians present there. Out of those civilians, PW1 is one. There, the vigilance inspector told me that PW1 made a complaint. The complaint was read over to us. PW1 stated that the accused demanded some money, the balance of which amounting to rupees 150 was to be paid by. It is demand by me established.
Yes. No, acceptance part. Let us go to the accept.
No, say demand kotha dekhontu tapare. Paragraph 3, let's go to para 3 at page 16.
A preparation report.
Preparation report was prepared at the IB. This is the preparation report marked exhibit 2/1. 2/2 is my signature. Then we proceeded to Gochapada on a jeep. At about 4 p.m., we reached at Gochapada. The vigilance inspector told us to stay near the office of lamps. The PW1 and the other civilian accompanying him went to the police station. So PW2 is at the lamps office, that is on the opposite side of the road from the police station, and PW1 and the other civilian, that is the deceased brother, they alone have gone to the police station.
No, that the PW1 also says, me and Digal went there.
ମୁଁ ମନା କରୁନି, ତାଙ୍କର ଏଭିଡେନ୍ସ ହେଲା ଭିଜିଲାନ୍ସ ଇନ୍ସପେକ୍ଟର ମତେ କହିଲେ ଲ୍ୟାମ୍ପସ ଅଫିସ ପାଖରେ ରହିବାକୁ, PW1 ଆଉ ଅଦର ସିଭିଲିଆନ ଗଲେ ପୋଲିସ ଷ୍ଟେସନ। ତାପରେ ତାଙ୍କର ନେକ୍ସଟ ସେଣ୍ଟେନ୍ସ ହେଲା 15 to 20 minutes thereafter vigilance inspector asked us to go to the police station. Thereafter vigilance staff went to the police station followed by me. Inspector commercial taxes also went to the police station with me. ତେଣୁ ଡିମାଣ୍ଡ ଆଜ୍ଞା କୋଉଠି ଆଙ୍କ ଉପସ୍ଥିତିରେ ନାହିଁ। At the police station, the vigilance inspector asked the accused to produce money received from PW1. Accused brought the currency notes. Thereafter, hands of the accused were washed with some solution. Solution changed its color to pink. So, Mishra, who according to PW1 is the person who has come and counted the money, he has not been examined. Now, this PW2, he says, he is a witness to having been present at the stage of preparation, heard from the complainant that the accused had demanded money from him, and then they had gone to that place, Gochapada. They stayed in the office of the lamps while PW1 and the other person went there. And 15 to 20 minutes thereafter, he followed the vigilance staff to the police station. There, vigilance inspector asked accused to produce money received from PW1. Accused brought the currency notes from his chest pocket. And by then, so the transaction is over. So neither he has seen demand and he has only seen the recovery of the currency notes from the chest pocket. So demand as stated by PW1 is not corroborated by PW2 as has been erroneously held by the trial court. Then your lordship may see what he has stated in cross-examination. Para 6 देखो, page 63. The IO seized the currency notes, shirt of the accused, slips of papers, counted the numbers and denominations of the currency notes, and hand wash of the accused in my presence, and prepared a seizure list. This is the currency seizure list marked Exhibit 7, under which the tented notes were seized. Under Exhibit IO also seized Exhibits 4 and 5, the 2 sheets containing numbers and denominations of the currency notes. He also seized the station diary book of the period 2110 to 4187 of the Gochapada PS, 1 FIR of Gochapada PS, personal diary of the accused, and non-FIR register of that police station, and prepared a seizure list, wide Exhibit 8. Cross-examination कहला, I saw those 2 civilians, one and another, for the first time at the minor irrigation IB, Fulband. Thereafter, I saw PW1 today in court. It is not possible for me to give the description of the other civilian. I could not have identified PW1 if I would have seen him in a gathering. So, he is identifying PW1 because he is seeing PW1 alone in court, because he was deposing in front of him. On the same day, he has deposed. This is what he says.
Yes.
Now, milords may see PW4, page 67. I know Boroza Diggle. In January 87, Vigilance seized some papers from Boroza. Above seizure was made in front of the Lamps house of Gochapada. Seizure list was prepared in my presence. I gave my signature thereon. Exhibit 10 is the seizure list. 10 by 1 is my signature. Now, if Borojo was an accompanying witness, means he has gone with the informant.
In the absence of Borojo, how will you?
No, sir, other circumstantial evidences are there. If my learned senior has completed, then I
No,
will.
no. I think that I have completed.
Please carry on.
Yes.
Tap रहेगा देखो. IOTA को देखो.
11.
What?
9 minutes.
9.
PW6 आगे देखो. PW6. 6 होची SI of Police Vigilance, who is a member of the vigilance team.
Page 70.
Your Lordship may look at paragraph 4 at page 72.
Yes. Thereafter,
we proceeded to Gochapada. Myself, DSP Tarafdar, Inspector Balaram Patnaik, Inspector Dandapani Patnaik, PK Sahu, complainant, official witnesses, Baidhar Diggle and others went in office jeep to Gochapada. Boroja Diggle was selected as overhearing witness and he was instructed to accompany the complainant to Gochapada PS. He was also instructed to hear the conversation between complainant and the accused at the police station. Overhearing witness was instructed to give signal by rubbing the right side of his head with his right hand at the time of demand and acceptance of bribe money. This is Boroju who has given this signal. PW1 does not say that also. PW1 ର evidence ହେଲା page 55 ରେ para 7, sixth line from the top. When he received the money, Boroja Digal went to inform the vigilance officer as was instructed.
When to inform. Here is the signal is on.
Signal କଥା କୋଉଠି କହିଛି ତେଣୁ ଏ ଜିନିଷଟା ବି corroborate ହଉନି ମୁଁ କହୁଛି from circumstances that his evidence is corroborated. ତାପରେ ଆଜ୍ଞା ଦେଖନ୍ତୁ the evidence of the vigilance witness ଦେଖନ୍ତୁ କେମିତି discrepant with that of PW1. It was decided that I along with Balaram would remain behind a bush which was near the police station, and the police station was visible to that place. The accused, being the officer in charge of Gochapada PS, was sitting on the outer veranda of the PS at the relevant time. Complainant along with overhearing witness went near the accused, and after receiving signal from the overhearing witness, we rushed to that place. PW1 जो कौच आमे गला को दी जण, me and the deceased, केवल मेलाराम थिला,
he was not there.
Accused not थिला.
जाइथिला
एटा भी आज्ञा corroborate होउनी. तापरे आज्ञा देखंतु look at the evidence of PW7.
Yes.
Who supports my plea and has not been declared hostile. Abhimanyu Behera,
PW7.
Page 76. On 3/11/96, I was attached to Gochapada PSS Police Havildar. On that day, I was directed by the OIC Gochapada to proceed to Oda Valley and to cut standing paddy with the help of laborers at Oda Valley and to give jima of paddy with the ward member after harvesting. Accordingly, I had been to village Oda Valley along with Gramarokhi Devaraj Digal on 29/11/86, got the standing paddy cut with the help of laborers in presence of leading persons of that area, and I gave jima of 2 tambis of paddy to Baraj Digal and returned to PS on 3/12/86. On 4/1/87, Bimbadhara Majhi accused ex-OIC Gochapada came to Gochapada on Jagannath Ratha duty, asked me to give a notice to the Jimadar, Sri Baraj Digal, to return 2 tambis of paddy kept in his jima to Labudu Kahara and Brendu Kahara by putting a backdate of 2/12/86. And in good faith, I issued a notice to Baraj Digal putting backdate of 2/12/86 to return the jima paddy to the aforesaid persons. So he has established, my lords, that Boroja had a grudge against me because I had instructed him to return the paddy to PW1. ତାପରେ ଆଜ୍ଞା ଦେଖନ୍ତୁ IO
83.
এটা TLO TLOଟାକୁ ଆଜ୍ଞା ଦେଖନ୍ତୁ page 86.
Yes.
At about 5:30 p.m. after getting signal of the overhearing witness, we rushed to the police station. After reaching the police station, we gave our identity to the accused. At that time, accused was sitting on a chair on the outer veranda of the PS. PW1 was standing near the accused. Overhearing witness was sitting on a bench. They also don't say that when the PW1 went, He doesn't say that he was not present and came later on. Then, my lords may see page 87, how Mishra was essential. Page 87 read, my lords may look at the first sub-paragraph.
Yes.
One Bonamali Mishra, who was available at the police station, was called to that place. Demonstration was shown to him regarding reaction of sodium carbonate solution with phenolphthalein. Hand wash water of that chance witness collected during demonstration kept in a separate bottle MO12. The sheets on which numbers of the currency notes were noted were seized from P. Surjanarayan and Vaidhara Singh as per Exhibit 12. Now, wasn't Mishra Millards a witness who should have been examined by the Vigilance? Then Millards may look at his cross-examination.
Yes.
Page 88, last sentence. It is not a fact, 4 lines from the bottom. It is not a fact that after our
arrival,
accused brought out the money from his pocket and produced the same, stating that money was given to Boros Diggle by him to supply wood. It is not a fact that hand wash of the complainant was taken thereafter. He was I have not noted in the case diary that no outsider was present at the time of detection of this case. It is not. That Hon'Ble Mishra and private were present at the time of detection of this case, Mr.
There's something missing.
Yeah.
One minute. PW7, na? I read it out.
ତାପରେ PW11 ଦେଖନ୍ତୁ.
No, you read from PW7.
Aye?
PW7 you are reading, na?
I was reading PW9.
9 you can read from. I read Kodji. Scan read Kodji.
Scan the ether jati was
Yes.
But this is the evidence. The appellant is dead.
Yes.
On this evidence, can it be said, my lords, that they have established demand and they have established acceptance? There is one small decision I'd like to cite. 87 Supreme Court 689. That's a division bench judgment. Balkishan Sayal versus State of Punjab. There, my lords, allegation was that a bribe was obtained. The court says like this. 2 outsider witnesses had been examined in the case, being Khajan Singh and Ramchandar, in support of the case. Khajan Singh, as noticed by the High Court, did not speak as to what transpired in the conversation between the bribe giver and the appellant. Other witness too was not very clear as to what talk preceded the passing of the 2 currency notes. High Court took the view that even if prosecution had not indicated what exactly the conversation was, once the passing of the 2 currency notes was accepted, it was for appellant to explain the circumstances under which the same had been received. That was negatived by the Honorable Court. The Lordship said, taking the unsatisfactory character of the prosecution evidence in regard to the conversation preceding the passing of the currency notes and the feature that for waiver of rupees 102, bribe of 100 was offered, we are inclined to take the view that prosecution fails to establish the case beyond reasonable doubt and appellant is entitled to this benefit.
Look. Yes.
My lords. My lords, I will just take your lordships to again the evidence of PW1, my lords, page 53. Page 53, para 2.
Yes.
That has been already placed. I'm just replacing it, my lords. The accused told me that he would take action on report only if I would give him rupees 500.
That's the demand you have.
That's the demand part. Then, my lords, PW2, your lordship, kindly come, page 16. He happens to be the magisterial witness. The first page 60, the last 3 lines. The PW1 stated the accused demanded some money, the balance of which amounting rupees 150 was to be paid by him.
Yes.
Then, my lords, PW6, page 71. 71, my lords.
That's for corroboration, you are saying.
Yes, my lords. He is the SI and he is a member of the trap party. Page 71, para 2. The sentence beginning, he complained before us that the accused standing in the dock. Lordship, have it, my lords.
Para 2.
Yes.
Which line? He complained.
Yeah.
Complained.
Yes, my lords. He complained before us that the accused standing in the dock, who was working as the OIC of Gochapada police station, had demanded rupees 500 to settle up a dispute between him and his father.
Yeah.
Then, Lordship, may kindly come to PW9, page 83.
83. Yes.
He's the IO, my lords, the TA, my lords.
Yes.
Page 83. First, my lord,
I introduced the complainant.
I introduced the complainant there, and the complainant narrated his affair story before them. The affair was also read out by me. He had bought rupees 150 for giving the same as bribe. And was thereafter, your lordship, kindly come to the judgment part, my lords. I've just pointed one, I will read only one paragraph, my lords. So far, the defense is concerned how it has been negated by the learned trial court below with proper analysis.
Yes.
Page 25, para 14 months. The judgment.
Yes.
The sentence beginning, it is worthwhile.
Yes. It is worthwhile.
It is worthwhile at this stage to consider the defense evidence. According to the defense, a sum of rupees 150 was given by Barash Digal to the accused, and the accused produced that money being asked by the vigilance inspector. In support of this plea of the defense, DW1 has been examined, who has stated that Barash Digal gave rupees 150 to the accused on the veranda of the police station. DW1 is a petition writer who used to write petitions sitting on the veranda of Gochapada police station. According to this witness, Barash Digal had taken rupees 300 from the accused for supply of wooden planks, and Barash Digal supplied planks worth of rupees 150, and that he did not supply the balance planks, for which he returned rupees 150 to the accused on the alleged date. It is not understood, this is important, it is not understood as to why Barash Digal came to return the money on the same day when a trap was arranged by the vigilance officers on the report of PW1. And if actually the money produced by accused was not given to him by PW1 and it was given to him by Barash Digal as contended by the defense, it is not understood, and this is important, it is not understood as to how the denomination and number of currency notes found place in the preparation report and exhibit 4 is the same. This is a very important observation. Thereafter, my lords, so far as the defense plea is concerned, they have taken this defense plea for the first time during trial. I am relying on one judgment of the Honorable Supreme Court in Tarsim Lal versus State of Haryana, 1982, page 806, where it says that defense plea taken first time during trial is an afterthought. Then, my lord, so far as the factum of demand is concerned, another case I will be replying upon, that is the case of B. Noha versus State of Kerala, and another reported in 2006, 12 SCC 277 at para 10. The Honorable Court observed that when it is proved that there was voluntary and conscious acceptance of the money, there is no further burden cast on the prosecution to prove any direct evidence, the demand or motive.
That presumption operates then.
Yes.
Once acceptance is there, it is he has to explain.
Yes.
Why it is accepted.
That's it.
That's how the judgments underline.
my reply. So far as the reasoning of the trial court, it is not understood as to why Borojo came to return the money on the same day when a trap was arranged. Now, the cardinal principle of criminal jurisprudence is that the prosecution has to prove its case. It cannot take advantage of the weakness of the defense. Prosecution case has to stand or fall on its own legs. This is probably basic to criminal jurisprudence. Now, what the learned judge has said here as to why Borojo came to return the money on the same day when a trap was arranged, the answer is PW6. PW6 was examined by the prosecution, which I placed before your lordship just now. Sarathi Patra.
There is enmity. That's what you pointed out. Page, I'll just. 77, page 77.
Aye.
Come to 77, para 2.
Aye.
Para 2, page
PW7, Abhimanyu Behe. Je kahila ki, I gave the jima of 2 tambis of paddy to Boros Digal and returned to PS.
On carry, get it recovered.
Aye.
That is the reason.
That is the reason here. And the other aspect, my lords, my learned friend says that defense plea was not taken at that time. Now, when will the defense plea be taken? It can only be taken at the trial. And what does he say that defense plea was not taken at that time? If your lordship will look at the evidence, once again, just a minute. That is PW6 again in cross-examination, page 75.
Yes.
He has denied it is not a fact, their cross-examination. Sorry, my cross-examination. It is not a fact that at the time of confrontation with the accused flatly denied to have received any bribe and stated that when Boros Digal had given him rupees 150 which he had taken for supplying planks. So this I have put at that time, my lords. Boros had come to that place as an overhearing witness. Hand wash of Boros Digal was not preserved.
Yes.
There is another evidence, my lords, that hand wash was not taken. I'll file a small note highlighting all these.
Along with the judgment. It's only one judgment you are relying upon.
I'll file 2 other judgments also.
Argument file. And the
I'll answer the
and within a week you file so that it's very difficult. And give the page number also.
Yes.
But your strength is PW1 only. That's the
Other circumstantial evidences are there.
If you very carefully see PW1, large part of it doesn't have any corroboration. And its variations are there.
And what is
if you take general principle, okay, no problem. You can convict. If you general principles are taken out, if you carefully read the evidences, it's very difficult.
Minor discrepancies adds flavors of truth.
Anyway, we'll see. Okay. Thank you.
Grateful.
Back to the easy. Yeah. Check code which is